Hello, hello. Andito na naman si Lolo Ray para sa isa na namang edisyon ng Layman's Terms. So ngayon po ay babasahin ko lang at susubukan kong i-discuss sa Tagalog. Subukan natin Tagalogin yung nakapaloob sa Labor Code of the Philippines. Labor Code of the Philippines, sabi niya rito. Ang Labor Code of the Philippines ay ang Presidential Decree number 442 as amended. It is a decree instituting a labor code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on social justice. Preliminary title. Ito. Basahin lang natin yung alaman niya. Chapter 1, General Provisions. Sabi niya, Article 1, Name of Decree. This decree shall be known as the Labor Code of the Philippines. Article 2, Date of Effectivity. This code shall take effect 6 months after its promulgation. Article 3, Declaration of Basic Policy. The state shall afford protection to labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, and regulate the relations between workers and employers. The state shall assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Article 4. Construction in favor of labor. All doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. Or sabi po, lahat ng pagdududa sa kung ano ba yung nais sabihin ng mga batas shall be construed, o ibig sabihin ay paniniwalaan na siya ay pumapabor lagi para sa mga manggagawa. Yun. Article 5. Wala ako. Article 5, Rules and Regulations. The Department of Labor and other government agencies charged with the administration and enforcement of this code or any of its parts shall promulgate the necessary implementing rules and regulations, period. Such rules and regulations shall become effective 15 days after announcement of their adoption in newspapers of general circulation. So, yun daw, yung mga government agencies daw ay gagawa ng mga implementing rules o yung tinatawag nating IRR. Yan yung nagpapaliwanag at nagbibigay linaw sa mga batas o anumang regulasyon na kanilang ipapalabas. Article 6, Applicability. All rights and benefits granted to workers under this code shall, except as many otherwise be provided herein, apply alike to all workers whether agricultural or non-agricultural. Okay, yun ang sabi sa applicability niya. Chapter 2. So lilinawin ko lang Article 1 to 6, siya yung general provisions. Chapter 1 yun. Okay. Chapter 2 naman, sinasabi niya yung emancipation of tenants. Article 7, Statement of Objectives. Inasmuch as the old concept of land ownership by a few has spawned valid and legitimate grievances that gave rise to violent conflict and social tension, and the redress of such legitimate grievances being one of the fundamental objectives of the new society, it has become imperative to start reformation with the emancipation of the tiller of the soil from its bondage. So, ibig sabihin nun, layunin ng batas na ito na bigyan ng mas maayos na kalagayan yung mga magsasaka, yung mga manggagawa. Ganda sana kung nasusunod. Article 8, Transfer of lands to tenant workers. Being a vital part of the labor force, tenant farmers on private agricultural lands primarily devoted to rice and corn under a system of sharecrop or lease tenancy, whether classified as landed estate or not, shall be deemed owner of a portion constituting a family-sized farm of 5 hectares if not irrigated and 3 hectares if irrigated. In all cases, the landowner may retain an area of not more than 7 hectares if such landowner is cultivating such area or will now cultivate it. Article 9. Determination of land value. For the purpose of determining the cost of the land to be transferred to the tenant farmer, the value of the land shall be equivalent to 2 1/2 times the average harvest of 3 normal crop years immediately preceding the promulgation of PD number 27 on October 21, 1972. Yan. The total cost of the land, including interest at the rate of 6% per annum, shall be paid by the tenant in 15 years or 15 equal annual amortizations. In case of default, the amortization due shall be paid by the farmers' cooperative in which the defaulting tenant farmer is a member, with the cooperative having a right of recourse against him. The government shall guarantee such amortizations with shares of stock in government-owned and government-controlled corporations. Okay, Article 10, Conditions of Ownership. No title to the land acquired by the tenant farmer under PD number 27 shall be actually issued to him unless and until he has become a full-fledged member of a duly recognized farmers cooperative. Title to the land acquired pursuant to PD number 27 or the land reform program of the government shall not be transferable except by hereditary succession or to the government in accordance with the provisions of PD number 27, the Code of Agrarian Reforms, and other existing laws and regulations. Article 11, Implementing Agency. The Department of Agrarian Reform shall promulgate the necessary rules and regulations to implement the provisions of this chapter. Article 11, pinaliwanag niya lang na ang agrarian reform ang bibigay ng kalagdagang mga supplements o kalagdagang mga regulasyon para ipatupad yung mga nabanggit natin. May idea dyan yung mga merong mga magsasaka na mga ninuno. Binabayaran nila yon ng naaayon sa kondisyon na sinaadi sa batas. Tapos, pwede yung ipamana by hereditary succession. Kaya lang masaklap nito, marami sa mga lupaing ganun naibenta na sa mga pribadong tao. Okay, punta naman tayo sa Book 1. Okay? So, linawin lang natin, yung mga nabasa natin is under the preliminary title. Punta naman tayo sa Book 1. Ang Book 1 ay tumatalakay sa pre-employment. Article 12, doon nagsisimula ang Book 1 ng Labor Code. Sabi sa Article 12, Statement of Objectives. It is the policy of the state to, ito yung mga sinasabi niya. A, promote and maintain a state of full employment through improved manpower, training, allocation, and utilization. B, to protect every citizen desiring to work locally or overseas by securing for him the best possible terms and conditions of employment. C, to facilitate a free choice of available employment by persons seeking work in conformity with the national interest. D, to facilitate and regulate the movement of workers in conformity with the national interest. E, to regulate the employment of aliens, including the establishment of a registration and or work permit system. F, to strengthen the network of public employment offices and rationalize the participation of the private sector in the recruitment and placement of workers locally and overseas to serve national development objectives. G, to ensure careful selection of Filipino workers for overseas employment in order to protect the good name of the Philippines abroad. So, napakaganda ng sinatalakay niya rito. Sabi niya to promote and maintain yung estado natin na merong full employment. Diba? Poproteksyonan niya daw yung mga citizens natin na nais magtrabaho dito man sa loob ng bansa o sa labas at ibigay sa kanila ang pinakamainam na kalagayan sa pagtatrabaho. facilitate a free choice of available employment para meron ka raw kalayaan na mamili ng trabahong na aayon sa'yo. D. Facilitate and regulate the movement of workers in conformity with the national interest. E. Sabi niya, to regulate the employment of aliens. Kaso parang, ewan ko lang. F. To strengthen the network of public employment offices and rationalize the participation of private sector in the recruitment and placement of workers. And sabi niya, G, sisiguruduhin niya yung mainam na pagpili ng mga Pilipino na magtatrabaho abroad para maproteksyonan yung pangalan at karangalan ng bansa natin sa abroad, sa ibang bansa, no? Pakaganda. Oh. Title 1. Dito naman ang tinalakay natin yon, Article 12, yun yung pre-employment. Title 1, under Book 1, tinatalakay naman dito yung recruitment and placement of workers. Chapter 1, General Provisions. Article 13, Definitions. So dito, dinidefine niya na yung mga terms. Okay? Ito yung mga terminologies na ginagamit sa pagtatrabaho, no? Definitions. A. Ang sabi niya, worker. Ang worker po ay any member of the labor force whether employed or unemployed. So, para sa technical na definition, may trabaho ka man o wala, ikaw ay considered na worker. Kasi sa hinaharap, pwede kang magtrabaho. You're part of the labor force. So, sa ating mga layman, sa ating mga ordinaryong tao, huwag tayong malilito ron. Yun yung definition ng batas. B. Recruitment and placement, ang ibig niya sabihin ay it refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring, or procuring workers and includes referrals, contract services, promising or advertising for employment locally or abroad, whether for profit or not, provided that any person or entity which in any manner offers or promises for a fee employment to two or more persons shall be deemed engaged in recruitment and placement. Yan ha. Malinaw po yun. C. Private fee charging employment agency means any person or entity engaged in recruitment and placement of workers for a fee which is charged directly or indirectly from the workers or employers or both. Ha? License. Ano naman ang ibig sabihin ng license? Ibig niya sabihin, it is a document issued by the Department of Labor authorizing a person or entity to operate a private employment agency. So, ang pinag-uusapan pong lisensya rito ay yung lisensya para ikaw ay mag-operate ng iyong pribadong employment agency. Private recruitment entity means any person or association engaged in the recruitment and placement of workers locally or overseas without charging directly or indirectly any fee from the workers or employers. On a side note, lagi po tayo mag-iingat na magbigay ng mga referral sa mga, minsan may nakikita ako sa mga Facebook na magbibigay ka ng referral sa iyong kababayan, tapos ibigyan ka raw nila ng bayad, pero ikaw po ay mag-ingat sapagkat kung illegal ang iyong pinagreferan doon sa iyong kapitbahay, inirefer mo siya kunwari dito sa isang nakilala mo lamang sa social media, tapos bibigyan ka raw ng cut o bibigyan ka ng sweldo, hindi mo naman alam yung kabuuan, hindi mo naman alam kung rehistrado ba sila, tapos napahamak pa yung nirefer mo, baka dawit ka sa kaso. Hindi pala baka, malamang dawit ka. So lagi po tayong mag-iingat, huwag tayong basta masilaw lagi sa pera. F. Authority means a document issued by the Department of Labor authorizing a person or association to engage in recruitment and placement activities as a private recruitment entity. Okay? O ito naman, pamilyar tayong lahat sa seaman. Seaman means any person employed in a vessel engaged in maritime navigation. So kahit na ano ka pa, basta na ikaw ay nagtatrabaho sa isang sasakyang pandagat at ikaw ay engaged sa maritime navigation. Overseas employment means employment of a worker outside the Philippines. Ibig sabihin, yung isang kababayan natin ay magiging isang empleyado sa labas ng ating bansa. Okay? Immigrant, letter E. Hindi yung I ha, E. Immigrant. So, alam ko immigrant ang pronunciation pero para lang alam natin na letter E siya. E-M-I-G-R-A-N-T means any person, worker, or otherwise who emigrates to a foreign country by virtue of an immigrant visa or resident permit or its equivalent in the country of destination. Magtungo naman tayo sa Article 14, Employment Promotion. Sabi rito, the Secretary of Labor shall have the power and authority to organize and establish new employment offices in addition to the existing employment offices under the Department of Labor as the need arises. Ito, kapangyarihan ito ng isang kapangyarihan ito ng Secretary of Labor. Isa pang kapangyarihan niya, to organize and establish a nationwide job clearance and information system to inform applicants registering with a particular employment office of job opportunities in other parts of the country as well as job opportunities abroad. Excuse me po, letter C. To develop and organize a program that will facilitate occupational, industrial, and geographical mobility of labor and provide assistance in the relocation of workers from one area to another. At sa huli, to require any person, establishment, organization, or institution to submit such employment information as may be prescribed by the Secretary of Labor. Magtungo naman tayo sa Article 15, Bureau of Employment Services. Letter A. The Bureau of Employment Services shall be primarily responsible for developing and monitoring a comprehensive employment program. It shall have the power and duty, number 1, to formulate and develop plans and programs to implement the employment promotion objectives of this title. Number 2, to establish and maintain a registration and or licensing system to regulate private sector participation in the recruitment and placement of workers locally and overseas, and to secure the best possible terms and conditions of employment for Filipino contract workers and compliance therewith under such rules and regulations as may be issued by the Minister of Labor. Number 3, to formulate and develop employment programs designed to benefit disadvantaged groups and communities. Number 4, to establish and maintain a registration and or work permit system to regulate the employment of aliens. Number 5, to develop a labor market information system in aid of proper manpower and development planning. Number 6, to develop a responsive vocational guidance and testing system in aid of proper human resources allocation. And 7, to maintain a central registry of skills except yung mga seamen. Okay? So yun po ang responsibilidad ng Bureau of Employment Services. Punta naman tayo sa letter B, Article 15 pa rin. The regional offices of the Ministry of Labor shall have the original and exclusive jurisdiction over all matters or cases involving employer-employee relations, including money claims arising out of or by virtue of any law or contracts involving Filipino workers for overseas employment except seamen, provided that the Bureau of Employment Services may, in the case of the National Capital Region, exercise such power whenever the Minister of Labor deems it appropriate. Ayan, ha? The decisions of the regional offices of the Bureau of Employment Services, if so authorized by the Minister of Labor, as provided in this article, shall be appealable to the National Labor Relations Commission upon the same grounds provided in Article 223 hereof. So pupuntahan natin yun mamaya. Hopefully, kayanin kong basahin ito at subukang ipaliwanag sa inyo. The decisions of the National Labor Relations Commission shall be final and inappealable. Pero ito ay superseded na ng Executive Order number 797 noong May 1982. So, appealable na siya. Ibig sabihin, gano'n. So, ang tinutukoy naman dito sa B ay yung regional offices ng Ministry of Labor. Sila lamang ang may original at katangi-tanging jurisdiction sa lahat daw ng mga matters na may kinalaman sa employer-employee relations, kasama na rito ang mga money claims arising out of or by virtue of any law or contracts involving Filipino workers para sa overseas employment. Hindi nga lamang kasama dito ang mga seamen. Okay? Punta naman tayo sa letter C. The Minister of Labor shall have the power to impose and collect fees based on rates recommended by the Bureau of Employment Services. Such fees shall be deposited in the National Treasury as special account of the General Fund for the promotion of the objectives of the Bureau of Employment Services, subject to the provisions of Section 40 of PD number 1177. Okay? Ilalagay ko rin po rito yung ibang link o yung link nitong mismong binabasa kong labor code sa internet para mabasa nyo rin. Magtungo na tayo sa Article 16, Private Recruitment. Except as provided in Chapter 2 of this title, no person or entity other than the public employment offices shall engage in the recruitment and placement of workers. Yun na, sabi niya, except as provided in Chapter 2 of this title, wala raw tao or korporasyon other than the public employment offices ang mag-i-engage o mag-i-engage sa recruitment and placement of workers. Punta naman tayo sa Article 17, Overseas Employment Development Board. An Overseas Employment Development Board is hereby created to undertake, in cooperation with relevant entities and agencies, a systematic program for overseas employment of Filipino workers in excess of domestic needs and to protect their rights to fair and equitable employment practices. It shall have the power and duty to, number 1, ito yung kapangyarihan ng Overseas Employment Development Board, number 1, to promote the overseas employment of Filipino workers through a comprehensive market promotion and development program. Number 2, to secure the best possible terms and conditions of employment of Filipino contract workers on a government to government basis and to ensure compliance therewith. Pangatlo, to recruit and place workers for overseas employment on a government to government arrangement and in such other sectors as policy may dictate. And ika-4, to act as secretariat for the Board of Trustees of the Welfare and Training Fund for Overseas Workers. Yan yung kapangyarihan ng Overseas Employment Development Board. Article 18. Ban on direct hiring. No employer may hire a Filipino worker for overseas employment except through the boards and entities authorized by the Secretary of Labor. Direct hiring by members of the Diplomatic Corps, international organization, and such other employers as may be allowed by the Secretary of Labor is exempted from this provision. So wala raw Pilipino ang nararapat na i-direct hire. Kasi nga naman, kailangan mo ng suriin ng boards and entities authorized by the Secretary of Labor yung magiging kalagayan ng kababayan natin bago siya magtrabaho. Article 19, Office of Immigrant Affairs. Pursuant to the national policy to maintain close ties with Filipino migrant communities and promote their welfare, as well as establish a data bank in aid of national manpower policy formulation, an Office of Immigrant Affairs is hereby created in the Department of Labor. The office shall be a unit at the office of the Secretary and shall initially be manned and operated by such personnel and through such funding as are available within department and its attached agency. Thereafter, its appropriation shall be made part of the regular general appropriations decree. Letter B, Article 19 pa rin to ha, Office of Immigrant Affairs. The office shall, among others, promote the well-being of immigrants and maintain their close link to the homeland by serving as a liaison, ano bang pronunciation ito? Serving as a liaison with migrant communities. Number 2, provision of welfare and cultural services. Number 3, promote and facilitate reintegration of migrants into the national mainstream. Number 4, promote economic, political, and cultural ties with the communities. And 5, generally to undertake such activities as may be appropriate to enhance such cooperative links. So ang tingin ko rito, ito yung may kinalaman dun sa mga pag napapanood yung programa ng mga kababayan natin sa abroad na meron silang mga cultural show kahit nasa abroad sila, ang tawag dito, meron silang yung mga nanonood ng NBA, yung merong Filipino Cultural Night sa Los Angeles, yung mga ganyan. Ang tingin ko may kinalaman itong Office of Immigrant Affairs at syempre may kinalaman sila doon sa ating embassy doon sa abroad, no? Article 20, National Seamen Board. Seamen po yung mga seafarers, ay mga seaman. Hindi yung seamen na iniisip mo hindi yun Okay. Sabi niya rito, a National Seamen Board is hereby created which shall develop and maintain a comprehensive program for Filipino seamen employed overseas. Ang kanyang powers and duties ay mag-provide ng libreng placement services for seamen. Number 2, to regulate and supervise the activities of agents or representatives of shipping companies in the hiring of seamen for overseas employment and secure the best possible terms of employment for contract seamen workers and secure compliance therewith. At pangatlo, to maintain a complete registry. Okay, so nakarehistro sila, nasa listahan ang lahat ng mga Filipino seamen. Pangalawa, ang sabi naman, itong National Seamen Board shall have original and exclusive jurisdiction over all matters or cases including money claims involving employer-employee relations arising out of or by virtue of any law contracts involving Filipino seamen for overseas employment. The decision of the board shall be appealable to the National Labor Relations Commission upon the same grounds provided in Article 223 hereof. So pupunta tayo dun mamaya. Pero itong sinasabi na National Seamen Board, Article 20, similar siya dun sa Saan ba yung, ito, the regional offices of the Ministry of Labor. Na binasa natin kanina under Article 15 na meron siya namang original and exclusive jurisdiction over all matters. Sabi ganyan. Or cases involving employer-employee relations, pati money claims. So, sa mga seaman, ito namang National Seaman Board. Yun naman, okay? Punta naman tayo sa Article 21, Foreign Service Role and Participation. Sabi rito, to provide ample protection to Filipino workers abroad, the labor attaché, ganun ba yan? Attaché. Labor attachés, the labor reporting officers duly designated by the Secretary of Labor and the Philippine diplomatic or consular officials concerned shall, even without prior instruction or advice from the Home Office, exercise the power and duty to, ito yung mga powers and duty nila, provide all Filipino workers within their jurisdiction assistance on all matters arising out of employment. Sana po itong mga labor attachés, diplomatic or consular officials, sana ginagawa nila talaga yung trabaho nila, no? B, to ensure that Filipino workers are not exploited or discriminated against. Masiguro nila, sana nadadalaw nila yung mga kababayan natin sa mga nasasakupan nila. Ewan ko nagagawa nila yan, parang hindi. Number C, to verify and certify as requisite to authentication that the terms and conditions of employment and contracts involving Filipino workers are in accordance with the Labor Code and rules and regulations of the Overseas Employment Development Board and National Seaman Board. Letter D, to make continuing studies or researches and recommendations on the various aspects of the employment market within their jurisdiction. Letter E, to gather and analyze information on the employment situation and its probable trends and to make such information available. And letter F, to perform such other duties as may be required from them from time to time. So ito yung tunay na mga gabay ng ating mga kababayan sa abroad. Sana naaasikaso ng mga labor attachés at ng mga diplomatic or consular officials yung mga kababayan natin, lalo na dun sa mga abuse-prone areas. Kadalasan yan, Middle East. Article 22, mandatory remittance of foreign exchange earnings. It shall be mandatory for all Filipino workers abroad to remit a portion of their foreign exchange earnings to their families, dependents, and or beneficiaries in the country in accordance with rules and regulations prescribed by the Secretary of Labor. So, mandatory po yan. Kailangan, kung ikaw ay OFW, kailangan ka mag-remit o magpadala ng portion ng iyong kinikita para sa mga pamilya mo rito, para sa mga dependents mo rito. Article 23, compositions of the boards. Ito yung mga opisyalis ng mga boards. Sabi rito, the OEDB. Ano ba yung OEDB? Siguro nabanggit na natin ito kanina. Office of Employment something. Nabanggit na natin ito kanina. The OEDB shall be composed of the Secretary of Labor as chairman, Undersecretary as vice chairman, representative ng bawat department ng Foreign Affairs, Department of National Defense, the Central Bank, Department of Education, Culture and Sports, DEX, DepEd na ito ngayon National Manpower and Youth Council, the Bureau of Employment Services, Workers Organization and an Employers Organization, and the Executive Director of the OEDB as members. Yun naman the National Seaman Board shall be composed of the Secretary of Labor and Employment as chairman, Undersecretary of Labor as vice, Commandant of the Philippine Coast Guard, and a representative each of the Department of Foreign Affairs, the Department of Education, Culture and Sports, the Central Bank, the Maritime Industry Authority, the Bureau of Employment Services, a National Shipping Association, and the Executive Director of the NSB o yung National Seaman Board as members. The members of the board shall receive their allowances. O, wag na yan. Number C naman, yung boards shall be attached to the Department of Labor for policy and program coordination. Letter D naman, the Auditor General shall appoint his representative to the boards to audit their respective accounts in accordance with auditing laws and pertinent rules and regulations. Sana itong Auditor General na ito ay hindi ko alam kung sa COA yung tinutukoy niya dito. Baka COA ito, Auditor General. Kailangan mai-audit yung kanilang pagpasok labas, pera-pera. Pero usually konsyaba yan sa mga nangungurakot, yung mga auditor, kinukonsyaba yan. So magpahinga mo, hindi, tapusin muna natin to. Article 24. Bago tayo magtungo sa Chapter 2, tapusin muna natin. Article 24, boards to issue rules and collect fees. The boards shall issue appropriate rules and regulations to carry out their functions. They shall have the power to impose and collect fees from employers concerned, which shall be deposited in the respective accounts of said boards and be used by them exclusively para i-promote ang kanilang mga objectives. So yun po mga binasa natin. Yan yung National Seamen Board. Yan. Okay. Mamaya-maya lamang natapos na natin ang Chapter 1. Ang Chapter 1 ay ang Recruitment, Title 1 pala yun. Pala yung Chapter 1. Ang Chapter 1 ay ang, nawala na ako. Tama. Ang Chapter 1 ay ang General Provisions. Yan, natapos na natin. Na-define na natin, nalaman na natin kung sino-sino ba yung magko-compose ng mga board, kung sino ba may jurisdiction ng mga problema arising out of employer relations and money claims na nag-a-arise dito. So mamaya-maya pupunta na tayo sa Chapter 2, which is yung Regulation of Recruitment and Placement Activities. Diyan lang kayo, walang bibitiw. Okay, so ako'y nagbabalik at hindi pa sigurado kung matatapos natin yung buong labor code sa isang live lang, pero subukan nga natin. Hindi ko kasi nagawang mag-aral nung araw, pero subukan ko na lang nabasahin itong mga ito para makatulong sa mga kababayan natin, ano? Yung mga nag-YouTube lang sa ganitong paraan, malalaman nyo na yung nilalaman ng labor code of the Philippines, no? Bago ang lahat, nais ko munang batiin si Pern-Ann. Maraming salamat sa iyo, Pern-Ann, French, Kaz, Panchang, and Kos. Maraming salamat sa inyong pagtitiwala at panonood at pag-iengganyo sa akin na gawin ito. Okay? So, ito. Marami na akong ginagawang content. Meron tungkol sa pag-ibig, meron tungkol sa usaping sex, at ngayon naman ay tungkol naman sa Philippine laws. Okay? Okay. Medyo nadidigay ako eh. Excuse me po. Okay. Chapter 2, Regulation of Recruitment and Placement Activities. Article 25, Private Sector Participation in the Recruitment and Placement of Workers. Pursuant to national development objectives and in order to harness and maximize the use of private sector resources and initiative in the development and implementation of a comprehensive employment program, the private employment sector shall participate in the recruitment and placement of workers locally and overseas under such guidelines, rules and regulations as may be issued by the SOLE. Yung SOLE po ay yung Secretary of Labor. Article 26, Travel Agencies Prohibited to Recruit. So sabi rito, travel agencies and sales agencies of airline companies are prohibited from engaging in the business of recruitment and placement of workers for overseas employment, whether for profit or not. So mag-iingat po tayo. Article 27, Citizenship Requirement. Only Filipino citizens or corporations, partnerships, or entities at least 75% of the authorized and voting capital stock of which is owned and controlled by Filipino citizens shall be permitted to participate in the recruitment and placement of workers locally or overseas. So kailangan daw yung may citizenship requirement. Tanging mga Filipino citizen lamang o yung mga korporasyon, partnership o an entity na at least 75% of the authorized and voting capital stock. Ito yung mga bumuboto sa isang korporasyon. Ibig sabihin may kapangyarihan, may boses sa isang korporasyon ay dapat owned and controlled by Filipino citizens. 75% of the authorized and voting capital stock. Ayun so yung may mga kaalaman dyan sa stock, pwede nyong i-comment sa baba kung ano nga ba yung voting and authorized stock na yan ng isang korporasyon. Pwede nyo po i-komento sa baba para sa aming karagdagang gabay. Okay, Article 28, Capitalization. All applicants for authority to hire or renewal of license to recruit are required to have such substantial o sapat na kapitalisasyon as determined by the Secretary of Labor. Article 29, non-transferability of license or authority. Hindi maaaring i-transfer yan sa ibang tao or ibang entity kung ikaw ay binigyan ng lisensya at ng authority ng ating gobyerno, hindi mo yan o in this case ng Department of Labor, hindi mo yan pwedeng i-transfer sa iba. Article 30, registration of fees. The Secretary of Labor shall promulgate a schedule of fees for the registration of all applicants for license or authority. Article 31, bonds. All applicants for license or authority shall post such cash and surety bonds as determined by the Secretary of Labor to guarantee compliance with prescribed recruitment procedures, rules, regulations, and terms and conditions of employment as may be appropriate. Ang bond po nito ay similar sa isang pagpapiyansa. Di ba? Ang piyansa, magbibigay ka ng pera, maglalaan ka ng pera, hahawakan mo na ito ng korte, tapos bibigyan ka niya ng pansamantalang kalayaan. Ang bond na ito will ensure na ikaw ay a-attend sa hearing kasi sayang naman yung pera mo. Di ba? Pag napawalang sala ka, pwede mong bawiin yung bond. Pag na-convict ka, hindi na. Ito naman, bond din, yung parang nagdeposito ka ba? Para pag nag-apply ka ng license or authority, masigurado nila na may kaugnayan dito dun sa sapat na capitalization o may pera ka ba, may sapat ka bang bond para masiguro mo na ikaw ay susunod sa mga regulasyon namin. So, kailangan may sapat kang halaga, no? Article 32, fees to be paid by workers. Any person applying with a private fee-charging employment agency for employment assistance shall not be charged any fee until he has obtained employment through its efforts or has actually commenced employment. Such fee shall always be covered with appropriate receipt clearly showing the amount paid. The Secretary of Labor shall promulgate a schedule of allowable fees. Article 33, reports on employment status. Whenever the public interest requires, the Secretary of Labor may direct all persons or entities within the coverage of this title to submit a report on the status of employment, including job vacancies, details of job requisitions, separation from jobs, wages, other terms and conditions, and other employment data. So, para lang sa kaalaman ng lahat, yung secretary po dito, pagka ginamit mo siya hindi lamang sa usapin ng labor, kundi sa usapin ng secretary sa government, sa gobyerno po matataas ang mga secretary. Sila po ang head ng isang ahensya, like the Secretary of Labor, the Secretary of Department of Justice, Secretary of Finance, etc. etc. Hindi po ito yung personal secretary na kunwari po ako ay YouTuber, tapos gusto ko merong nagpapaalala sa akin, merong sumusulat sa akin na batiin mo si ganito or timplahan niya ako ng kape, siya ay aking personal na aalalayan niya ako. Hindi po gano'n ang secretary sa government terms at hindi rin po gano'n yung Secretary of Labor na pinag-uusapan natin dito Okay. Article 34, prohibited practices. It shall be unlawful for any individual, entity, licensee, or holder of authority to, ito yung mga pinagbabawal to charge or accept directly or indirectly any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary of Labor, or to make a worker pay any amount greater than that actually received by him as a loan or advance. Bawal din to furnish or publish any false notice or information or document in relation to the recruitment or employment. Bawal din to give any false notice, testimony, information or document, or commit any act of misrepresentation for the purpose of securing a license or authority under this code. Basta bawal dito magsinungaling, bawal dito manloko. Bawal din to induce or attempt to induce a worker already employed to quit his employment in order to offer him another employment. Sasabihin mo sa kanya, malis ka na dyan, bibigyan mo mas maganda. Bawal po yun unless the transfer is designed to liberate the worker from oppressive terms and conditions of employment. unless yung transfer niya, sinabi mo, umalis ka na dyan, bibigyan kita ng mas magandang pagkakataon, is because inaabuso siya doon. Okay? Bawal din to influence or attempt to influence any person or entity na huwag tanggapin sa trabaho ang isang worker who has not applied for employment through his agency. Bawal manira talaga, no? Bawal din to engage in the recruitment or placement of workers in jobs harmful to public health or morality or to the dignity of the Republic of the Philippines. Pinakamagandang example niyan, bawal mag-recruit ng prostitute sa abroad, di ba? Letter G, bawal din to obstruct or attempt to obstruct inspection by the Secretary of Labor or by his duly authorized representatives. Bawal yun. Diba sa mga pulis, pag hinarangan mo hindi mo pinahintulutang gawin nila ang trabaho nila, ang tawag doon, obstruction of justice, di ba? Pag nanonood kayo sa balita, yung nagwawala-wala, aarestuhin, yung isang dapat naman arestuhin, pero nagwala-wala yung kamag-anak, pwede sila makasuhan ng obstruction of justice. Ganon din doon. Bawal mong harangan yung isang inspeksyon ng Secretary of Labor or by his duly authorized representatives. Bawal yun, ha? Bawal din to fail to file reports o yung mabigo ka na mag-file ng report on the status of employment, placement vacancies, remittance of foreign exchange earnings, separation from jobs, departures, and such other matters or information as may be required by the Secretary of Labor. Ito yung mga bawal gawin ng bawat tao, entity, licensee, o sino mo may hawak ng karapatan na mag-recruit, ha? Bawal din to substitute or alter employment contracts na naaprubahan na and verified by the Department of Labor from the time of actual signing thereof by the parties up to and including the periods of expiration of the same without the approval of the Secretary of Labor. Bawal mong palitan yun without the approval of the Secretary of Labor. Bawal din to become an officer or member of the board of any corporation engaged in travel agency or to be engaged directly or indirectly in the management of a travel agency. Bakit? Kasi po, conflict of interest yun. Diyan lalabas yung corruption na travel agency na lang natin yung gamitin. Conflict of interest po yan. Pero sad to say, marami sa gobyerno. And letter K, bawal daw to withhold or deny travel documents from applicant workers before departure for monetary or financial considerations other than those authorized under this code and its implementing rules and regulations. So, madaling salita, bawal mong kikilan isang manggagawa. Bawal mong itago yung kanyang mga travel documents. Diba? Lalo na kung sinisingil mo lang naman illegal o hindi naman nakasaad sa labor code or dun sa implementing rules and regulations. Ito pong binabasa ko, itong labor code, ha. Marami pong mga implementing rules at iba pang batas na may kinalaman o ang basihan nila ay itong labor code. Okay? Magtungo na tayo sa Article 35. Suspension and or cancellation of license or authority. The Minister of Labor shall have the power to suspend or cancel any license or authority to recruit employees for overseas employment for violation of rules and regulations issued by the Ministry of Labor, the Overseas Employment Development Board, siguro ito na yung POEA sa ngayon, di ko lang sure, or for violation of the provisions of this and other applicable laws, general orders, and letters of instruction. So, pwedeng suspindihin o tanggalan ka ng lisensya o ng karapatan, ha? Punta naman tayo sa Chapter 3. Chapter 3, nagsisimula sa Article 36. Chapter 3 na tayo. Ito naman yung Miscellaneous Provisions. Sinasabi niya lang, Article 36, regulatory power. The Secretary of Labor shall have the power to restrict and regulate the recruitment and placement activities of all agencies within the coverage of this title and is hereby authorized to issue orders and promulgate rules and regulations to carry out the objectives and implement the provisions of this title. Meron din siyang visitorial power. Article 37, yung Secretary of Labor o ang kanyang mga authorized representatives at any time may inspect premises, books of accounts, and records of any person or entity covered by this title at i-require sila na magsumite ng mga reports regularly on prescribed forms and act on violation of any provisions of this title. So, kailangan may gawin yung Secretary of Labor at authorized representatives niya. Problema lamang, parang hindi naman yata ginagawa. Charot. Punta naman tayo sa Article 38. Babasahin ko lang yung nakalagay sa Labor Code. Hindi ko lang sigurado kung meron ng special law o yung bagong law na nagsusupersede. Dito, Article 38, illegal recruitment. This is a criminal violation, ha? Ito yung sinasabi sa illegal recruitment. Letter A. Any recruitment activities including the prohibited practices enumerated under Article 34, o kasama tayong nabasa natin kanina na pinagbabawal na practices to be undertaken by non-licensees or non-holders of authority shall be deemed illegal and punishable under Article 39 of this code. Sa Article 39, yung kasunod nito, yung penalties sinasabi. The Department of Labor and Employment or any law enforcement officer may initiate complaints under this article. Okay, so the DOLE or any law enforcement officer pwedeng mag-initiate ng complaint dahil sa artikulo na ito. Ulitin ko, hindi ko lang alam kung may special law na pumalit dito. Letter B, illegal recruitment when committed by a syndicate or in large scale shall be considered an offense involving economic sabotage and shall be penalized in accordance with Article 39. Sigurado mas mataas ang penalty nito. Sabi niya rito kasi, ang illegal na recruitment is deemed committed o pinagpapalagay na ginawa ng isang sindikato kapag ito ay ginawa ng grupo of 3 or more persons na nag-conspire o nagsama-sama, nagplano, confederating with one another in carrying out any unlawful or illegal na mga transaksyon, enterprise, or scheme defined under the first paragraph hereof. Illegal recruitment is deemed committed in large scale if committed against 3 or more persons individually or as a group. So kahit isa ko lamang, pero ginawa ko siya sa 3 tao, yun ay illegal recruitment in large scale. Mabigat, mas mabigat. Kapag naman 3 kami kunwari, 3 kami o higit pa, na nagplano-plano kaming mag-recruit ng mga tao, that is illegal recruitment by a syndicate. At yung itong dalawang nabanggit na to, mabigat siya kasi parang it is an offense involving economic sabotage. So parang sinasabotahe mo yung ekonomiya natin. Kasi, di ba, ang dami yung nagpaplano ng kalokohan, o di naman ang dami ninyong niloko. Imbis na nakakatulong sa pamilya, nakakaperwisyo ka sa kaligtasan at sa ekonomiya ng ating bayan. At letter C, isa pang sinasabi sa illegal recruitment, the Secretary of Labor and Employment or his duly authorized representatives ay merong kapangyarihan to cause the arrest and detention of such non-licensee or non-holder of authority if after investigation it is determined that his activities constitute a danger to national security and public order or will lead to further exploitation of job seekers. So may kapangyarihan ng Secretary of Labor yan. Article 39, kayo na magbasa, sinasabi rito yung penalties. No? Mabigat po mga penalties. Tungo naman tayo sa Title 2. Ito naman yung employment ng non-resident aliens. At ang Title 2 ay nagsisimula sa Article 40. Employment permit of non-resident aliens. Sinasabi lamang dito na any alien seeking admission to the Philippines for employment purposes and any domestic or foreign employer who desires to engage an alien for employment in the Philippines shall obtain an employment permit from the DOLE. Yun na lang. Okay, Article 41, Prohibition against transfer of employment. So kapag daw inisyo na ang iyong employment permit, etong alien na to ay hindi niya pwedeng ilipat sa ibang, hindi siya pwedeng lumipat ng trabaho or change an employer without prior approval of the Secretary of Labor. At any non-resident alien na magtatrabaho rito at magva-violate ng provision ng batas na ito ay paparusahan in accordance with Articles 289 and 290 of the Labor Code. Siguro nandoon yung kaparusahan nito. Basahin na lang natin sa mga susunod o kung awat tayo doon. So, Article 42, Submission of List. Ayan, sinasabi lang naman na any employer employing non-resident foreign nationals on effective date of this code shall submit a list of such nationals to the Secretary of Labor within 30 days after such date, indicating their names, citizenship, foreign local addresses, nature of employment, and status of stay in the country. The Secretary of Labor shall then determine if they are entitled to an employment permit. So, magpapasa po ang isang employer dito ng listahan. Kaya lang parang kulang, parang marami nagtatrabaho dito, lalo na mga in-chick na parang kulang sa dokumento. Parang pag tinanong mo saan ba nakatira yan, ano bang address China niyan, hindi natin matukoy. Parang maraming ganun. Okay. So, book 2 naman, ang sinasabi ng book 2 dito sa Labor Code, ito yung Labor Code. Ito yung Human Resources Development Program. So, nagsisimula ito sa Title 1, National Manpower Development Program. Sinasabi niya lang naman yung mga national policies. 43, yung Statement of Objective. Article 44, yung definition. Sinasabi rito, manpower shall mean that portion of the nation's population which has actual or potential capability to contribute directly to the production of goods and services. Similar dun sa sinabi natin kanina, worker, whether employed or not, basta pwede ka magtrabaho, worker yun. Entrepreneurship shall mean training for self-employment or assisting individual or small industries within the purview of this title. So ito po yung tinapos ko sa kolehiyo, BSBA major in Management and Entrepreneurship. Okay. Article 45, National Manpower and Youth Council. Nasabi rito yung mga members nila. Hindi ko nababasahin yan. Okay. National Manpower Plan. Ayan. Industry Boards. Nasabi lang naman dyan. Incentive Scheme. Council Secretariat. Yung Article 53. Subukan natin tignan yung mga mas importante pa. No? Ito naman, Title 2. Ang Title 2 ay may pamagat na Training and Employment of Special Workers. Okay. Chapter 1, Apprentices. Okay. Siguro narinig nyo na yung term na apprentices. Sabi rito, Article 57, Statement of Objectives. Okay. This title aims to help the demand of the economy for trained manpower, establish a national apprenticeship program, establish apprenticeship standards. Okay. So, tingnan natin para mas maintindihan natin. Article 58, Definition of Terms. Apprenticeship means practical training on the job supplemented by related theoretical instruction. B. An apprentice is a worker who is covered by a written apprenticeship agreement. So, sa tunay na buhay, basta meron kang apprenticeship agreement, yun ang kaibahan mo sa ibang empleyado. Ganun lang naman yun eh. An apprenticeable occupation means any trade, form of employment or occupation which requires more than 3 months of practical training on the job supplemented by related theoretical instruction. Ang apprenticeship agreement is an employment contract wherein the employer binds himself to train the apprentice and the apprentice in turn accepts. So mahalaga po yun yung employment contract nila, kailangan yung employer sinisiguro niya, pumapayag siya na i-training niya si apprentice, at kailangan si apprentice naman tinatanggap niya. So may meeting of the minds, may kontrata, may apprenticeship agreement. Okay? Qualifications ng apprentice, kailangan at least 14 years of age, merong vocational aptitude and capacity for appropriate tests. Siya ay nagtataglay ng ability to comprehend and follow oral and written instructions. Okay? Okay, puro apprenticeship na to. Punta naman tayo sa chapter 2, yung learners. Okay? Ang learners naman ay magsisimula sa article 7 to 3. So bago natin basahin yung learners, mag-iinit muna ako ng ulam ko. Magbe-break lang ako. Diyan lang kayo. Okay. Okay. Tuloy natin ang ating pinag-uusapan. Nandito na tayo sa Chapter 2, which is pinamagatang The Learners. Ayan Article 73 nagsisimula ang Chapter 2 at sabi rito, learners are persons hired as trainees in semi-skilled and other industrial occupations which are non-apprenticeable and which may be learned through practical training on the job in a relatively short period of time, which shall not exceed 3 months. Article 74. When learners may be hired. Learners may be employed when no experienced workers are available. Yun na lang sabihin natin, okay? Article 75. Learnership agreement. An employer desiring to employ learners shall enter into a learnership agreement. Nakalagay daw doon yung names and addresses ng learners. The duration of the learnership period which shall not exceed 3 months. The wages or salary rates of the learners which shall begin at not less than 75% of the applicable minimum wage. So, kailangan at least 75% ng applicable minimum wage. And letter D, a commitment to employ the learners if they so desire as regular employees upon completion of the learnership. All learners who have been allowed or suffered to work during the first 2 months shall be deemed regular employees if training is terminated by the employer before the end of the stipulated period through no fault of the learners. Ang masakit lang talaga lagi, naku po. Minsan nga may kontrata 5 months lang para anyway, learners similar din sila dun sa kanina, yung apprentice. May kaibahan sila which is very very minimal lamang basahin na rin natin tong Article 76, learners in piecework. So learners employed in piece or incentive rate jobs during the training period shall be paid in full for the work done. So ito yung mga piecework lang. Kunwari learner ka ng paggawa ng parol, so babayaran ka base lamang sa ginawa mo. Article 77, penalty clause, ang pagbabiolate daw ng chapter na ito o ang kanyang mga IRR. Muli ko ipapaliwanag, bawat batas sa mga labor code, meron niyang mga implementing rules na nakapaloob. Ang paglabag doon ay may kaparusahan. Okay? Magtungo naman tayo sa Chapter 3, Handicapped Workers. Ito yung those whose earning capacity is impaired o yung kapasidad nilang kumita ay nabawasan dahil sa age or physical or mental deficiency or injury. Okay, may kapansanan sila. Article 79, sinasabi rito na handicapped workers may be employed when their employment is necessary to prevent curtailment of employment opportunities and when it does not create unfair competition in labor costs or impair or lower working standards. So alam ko meron ng batas sa mga handicap ngayon Okay, meron ng batas dyan kung di ako nagkakamali. Book 3 naman, magtungo tayo rito. Ang sinasabi rito, Conditions of Employment. Ang title 1 itong book 3 natin ay Working Conditions and Rest Periods. Ang chapter 1 ng Working Conditions and Rest Periods ay yung Hours of Work. Okay? Nagsisimula siya sa Article 82, which is ipinaliliwanag niya yung coverage. Okay? So, sandali lang, ayusin ko lang yung fan ko. Ah, marami akong electric fan. Pagka tinutok, malamig. Pag inikot, mainit. Ayaw ko talaga na nakatutok. Oh, anyway, nandito na tayo muli. Article 82, ito yung coverage ng hours of work. O, sabi rito, the provisions of this title shall apply to employees in all establishments and undertakings whether for profit or not, but not to government employees. So, hindi kasali ang government employees, managerial employees, field personnel, members of the family of the employer who are dependent on him for support, domestic helpers, persons in the personal service of another, and workers who are paid by results as determined by the Secretary of Labor. So, ang sabi rito, ang managerial employees refer to those whose primary duty consists of the management of the establishment in which they are employed or of a department or subdivision thereof, and to other officers or members of the managerial staff. Ang field personnel naman daw shall refer to non-agricultural employees who regularly perform their duties away from the principal place of business or branch office of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty. So, hindi talaga sila nga naman kasama doon. Ano po? Article 83, normal hours of work. Ipaliliwanag dito. Normal hours of work of any employee, sabi niya, shall not exceed 8 hours a day. Pero sad to say, no? Napakaraming lumalagpas sa 8 hours per day, no? Tapos hindi sila compensated. Health personnel in cities and municipalities with a population of at least 1 million or in hospitals and clinics with a bed capacity of at least 100 shall hold regular office hours for 8 hours a day for 5 days a week, exclusive of time for meals, except where the exigencies of the service require that such personnel work for 6 days or 48 hours, in which case they shall be entitled to an additional compensation of at least 30%. Dapat pala ganun, no? Of at least 30% of their regular wage for work on the 6th day. So, ayon sa batas, kunwari, nagtatrabaho ka ng 5 araw sa isang linggo, pero kinakailangan magtrabaho ka dun sa Sabado, dapat yung sweldo mo sa isang araw plus 30%, dapat ganun. Sabi rito, sa sa mga health personnel, sabi rito, for purposes of this article, health personnel shall include resident physicians, nurses, nutritionists, dietitians, pharmacists. Yung best friend ng kapatid ko is a pharmacist. Social workers, kasama pala sa social workers, kasama pala sila sa health workers, laboratory technicians, paramedical technicians, psychologists, midwives, attendants, and all other hospital or clinic personnel. Article 84, hours worked. Hours worked shall include all time during which an employee is required to be on duty or to be at a prescribed workplace, and B, all time during which an employee is suffered or permitted to work. Okay? Rest periods of short duration during working hours shall be counted as hours worked. So dapat pala ang pasok ay 8 to 4 kasi counted sa hours worked yung rest periods. Charot. Hindi, mali yun Okay. Dapat ang pasok pala 8 to 4, Hindi 8 to 5. Para 8, 9, 10, 11, 12, 1, kasama yung 12 to 1, 2, 3, 4, 8 hours yun, Pero hindi, ang sinasabi lang dito, rest periods of short duration, hindi na makasali yung meal periods. Sabi dito sa Article 85, meal periods subject to such regulations as the Secretary of Labor may prescribe. It shall be the duty of every employer to give his employees not less than 60 minutes. Hindi bababa sa 60 minutes para sa kanilang pananghalian. Okay? O kung sa gabi man yan, hapunan siguro, Article 86, night shift differential. Every employee shall be paid a night shift differential of not less than 10% of his regular wage for each hour So, kunwari, ang sweldo ko sa isang maghapon ay 400 pesos. Kunwari lang. So, that is, 800 pesos na lang para madali. That is 10 pesos per hour. Tama ba? Hindi. 800 pesos. Parang ang hirap naman ng math. So, 8 hours a day, 100 pesos ako per hour. So, 10% nun is 10. So, dapat 110 pesos per hour ako doon sa mga oras na ako between 10 o'clock in the evening and 6 o'clock in the morning. So, kung nagtatrabaho ako ng 10 o'clock in the evening, sa pagitan ng 10 o'clock in the evening hanggang 6 a.m., dapat ang sweldo ko nun, based on my example, kunwari 100 pesos per hour ako, 800 pesos per day ang sweldo ko. Dapat ang magiging sweldo ko from 10 o'clock to 6 is 110 o yung dagdag na 10% ng iyong not less than 10% of shall be paid an issue differential of not less than 10%. Oh, tama. Hindi bababa sa 10% of his regular wage for each hour work performed. Yun ang sinasabi niya rito, ha. Hindi bababa, tama nga ako. So, 100 pesos ako kunwari per hour, magiging 110 pesos per hour ako. Sabi rito, Okay, Article 87. Overtime work. O kunwari ko lang yun, parang mali ako. Hindi, parang basta not, sabi rito, every employee shall be paid an IC differential of not less than 10% of his regular wage for each hour. So, tama ako doon sa example ko. Okay. Article 87, overtime work. So, sabi rito, work may be performed beyond 8 hours a day provided that the employee is paid. Dapat may kapalit for the overtime work. Karagdagang compensation na equivalent to his regular wage plus at least 25% thereof. Okay? Work performed beyond 8 hours on a holiday or rest day shall be paid an additional compensation equivalent to the rate of the first 8 hours on a holiday or rest day plus at least 30% thereof. So, sabi rito, math na naman, ha. Work na ginawa na lumagpas sa 8 hours a day, kailangan ang empleyado ay babayaran mo ng overtime work, overtime compensation. So, at least 25% thereof. So, kunwari, 100 pesos ako per hour, 25% nun, so 125 ang ibabayad mo sa akin sa bawat oras na lalagpas ako ngayon. Ngayon, beyond 8 hours on a holiday or rest day, may additional compensation na 30%. Diba? So, kumbaga, holiday or rest day na, pag holiday or rest day kasi 30%. Kung 100 pesos per hour ako, magiging 130 pesos per hour ang sweldo ko. Lumagpas pa ako, nag-overtime pa ako noon. 25% pa noon. Gets ba? So, kung 100 pesos ang normal kong sweldo, nagtrabaho ako ng rest day or holiday, naging 130 pesos ako per hour. Kasi nga, holiday, nag-fall ng holiday. Nag-overtime pa ako noon. So, ano yung 25% ng 130? So, idadagdag ko 130 plus yung 25% nun. Ganun po, ha. Kung may komento po kayo, kung may mas nakakaalam, kung ako'y may pagkakamali, comment nyo lang po, lalo na kung may abogadong nakakapanood sa atin, okay? Sabi rito sa Article 88, undertime not offset by overtime. Undertime work on any particular day shall not be offset by overtime work on any other day. Permission given to the employee to go on leave on some other day of the week shall not exempt the employer from paying the additional compensation required in this chapter. Kasi nga, mas malaki ang pwede mong kitain kapag gabi o another day which is rest day. Article 89, emergency overtime work. Any employee may be required by the employer to perform overtime work in the following cases. Kapag daw ang bansa ay nasa giyera, sa A, or when any other national or local emergency has been declared by the National Assembly or the Chief Executive. B, when it is necessary to prevent loss of life or property or in case of imminent danger to public safety due to an actual or impending emergency in the locality caused by serious accidents, fire, flood, typhoon, earthquake, epidemic, or other disaster or calamity, yan, mga kalamidad, pwede kang i-require mag-overtime. Letter C, when there is urgent work to be performed on machines, installations, or equipment in order to avoid any serious loss or damage to the employer or some other cause of similar nature. D, when the work is necessary to prevent loss or damage to perishable goods, yan, mga napapanis, pwede ka nilang i-ask na mag-overtime. And letter E, where the completion or continuation of the work started before the 8th hour is necessary to prevent serious obstruction or prejudice o huwag tayo magdulot ng pinsala sa business operations ng employer. Pwede kanyang i-require sa mga pagkakataong yon na mag-overtime pay, na magtrabaho overtime. Okay? And okay, Article 90 naman, computation of additional compensation for purposes of computing overtime and other additional remuneration as required by this chapter. The regular wage of an employee shall include the cash wage only. Hindi po kasama yung deduction on account of facilities provided by the employer. Yung cash lamang. Kagaya ng example ko kanina, kung 100 pesos per day tumatapat ako, boom, yun ang pagbabasehan. Okay? So, nakakapagod palang mag-vlog ng ganito, ano? Pero subukan natin ituloy. Kakain lamang ako at tuloy ang ligaya. Sarap. O, tapusin ko na muna itong subukan natin to. Chapter 2, yung weekly rest periods, nagsisimula siya sa Article 91, sabi lang dito naman, right to weekly rest day. So, kailangan lang daw may weekly rest day, not less than 24 consecutive hours after every 6 consecutive normal work days. Yun, karapatan yun. Article 92, when employer may require work on a rest day, ganun na rin, similar doon sa sinabi natin kanina. Article 93, compensation for rest day, Sunday or holiday work. Sabi rito, pag pinagtrabaho siya ng linggo, holiday work or rest day, dadagdagan siya ng at least 30%. Yan, nabanggit na natin yan kanina. Okay? Holiday, service incentive leaves, and service charges. Article 94, the right to holiday pay. Sabi. Every worker shall be paid his regular daily wage during regular holidays except in retail and service establishments regularly employing less than 10 workers. So, pag less than 10 ang trabahador mo, regular daily wage lang. The employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice, so doble. So, kung 100 pesos per day ako, magiging 200 pesos per day pag nagtrabaho ako sa holiday. Ito yung holiday pay. As used in the article, holiday means, ito yun, New Year's Day, Maundy Thursday, Good Friday, yan, para sa mga Katoliko po and kahit hindi Katoliko, basta sineselebrate nationwide ito The 9th of April, the 1st of May, yan yung Labor Day, the 12th of June, the 4th of July, the 30th of November, the 25th and 30th of December, and the day designated by law for holding a general election. Baka nadagdagan na ito. Hindi na kompleto yata ito. Article 95, right to service incentive leave. Yan. Sabi rito, every employee who has rendered at least 1 year shall be entitled to a yearly service incentive leave of 5 days with pay. Okay? Basta naka-isang taon ka na empleyado ng isang kumpanya. Okay? Na isang private. Ito provision na to will not apply to those who are already enjoying the benefit herein provided, those enjoying vacation leave with a pay of at least 5 days, and those employed in establishments regularly employing less than 10 employees or in establishments exempted from granting the benefit. So pagka sa retail basta sa retail service, kung less than 10, hindi mo naman kailangang magbigay kung ikaw ay employer ng service incentive leave. Okay? Mahalaga po rito yung sa isang employer malaman mo na kung less than 10 ang trabahador mo, hindi ka required na magbigay ng service incentive leave. Article 96, service charges. All service charges collected by hotels, restaurants, and similar establishments shall be distributed at the rate of 85% for all covered employees and 15% for management. Okay, so ito yung mga tip. Service charges, 85%. Nagsasama-samahin yan para sa mga empleyado, 15% sa management. Ganun yan, ha? O, pupunta naman tayo sa Title 2, which is yung wages. Ano bang sabi rito? Article 97, definition of terms. Sabi niya, person means an individual, partnership, association, corporation, business trust, legal representatives, or any organized group of persons. Employer includes any person acting directly or indirectly in the interest of an employer in relation to an employee shall include the government and all its branches, subdivisions, and instrumentalities, all government-owned and controlled corporations and institutions, as well as non-profit private institutions or organizations. Employee includes any individual employed by an employer. Agriculture includes farming in all its branches, lahat-lahat na yan. Employ includes to suffer or permit to work. Ibig sabihin ng nag-employo ka, you suffer or you are permitted na magtrabaho, no? Permitted or made to suffer to work. Wage paid to any employee shall mean the remuneration or earnings. Earnings, however designated, capable of being expressed in terms of money, whether fixed or ascertained on a time, task, piece, or commission basis, or other methods of calculating the same, which is payable by an employer. Binabayaran ito ng isang employer sa kanyang trabahador under a written or kahit na wala pang written contract of employment, for work done or to be done, or for services rendered or to be rendered, and includes fair and reasonable value as determined by the Secretary of Labor, of board, lodging, or other facilities customarily furnished by the employer to the employee. Fair and reasonable shall not include any profit to the employer or to any person affiliated with the employer. At panandalian tayo magtatapos dito sa Article 98. Sabi lamang dito, this title shall not apply to farm tenancy or leasehold. Hindi siya kasama doon. Domestic service and persons working their respective homes in needlework or in any cottage industry. Yung mga mananahi po, yung mga nasa farm tenants, nasa cottage industry, hindi po sila kasali dito sa pinag-usapan natin dito sa title na ito, which is yung wages. Okay? Mamaya pupunta tayo sa minimum wage rates at payment of wages. Sa aking pagbabalik, kakain lang ako. Huwag kayo alis. Ayun, okay. So ako'y muling nagbabalik. Nakatapos ko lang itong kumain, ano? At tinatry ko kung kaya kong tapusin ang buong labor code uh, in layman's terms. Itong bago natin programa. Try ko siyang tapusin buo sa isang upuan lamang. So tinitignan ko kung ito, magdadalawang oras na tayong live. Tinitignan ko kung possible ba na siya ay ma-upload pa rin o ma-save ko ba siya. Okay? It's such a shame pag hindi ito na-save dahil dami natin binasa. Okay, so punta na tayo sa Chapter 2, Minimum Wage Rates. Sabi rito, Article 99, Regional Minimum Wages. The minimum wages rates for agricultural and non-agricultural employees and workers in each and every region of the country shall be those prescribed by the regional Tripartite Wages and Productivity Boards. So, sila magtatakda niyan. Article 100, Prohibition against elimination or diminution of benefits. Sabi, wala raw kahit na ano paman na isinulat dito sa libro na ito ang dapat i-interpret o shall be construed to eliminate or in any way diminish o babaan ang mga supplements or other employee benefits na ini-enjoy nila bago pa man magawa ang code na ito. Pwede natin itong i-relate sa sinasabi natin kanina nung beginning part natin na ano man na hindi natin maintindihan o ano man yung malabo shall be construed or ating uunawain na pumapabor sa ating mga manggagawa o sa labor, no? Okay, Article 101, Payment by Results. Yung iba hindi ko nababasahin po, ha? Okay, so basahin na lang natin yung Chapter 3, Payment of Wages. Article 102, Forms of Payment. Sabi rito, kailangan daw hindi raw pwedeng magbayad ang employer sa pamamagitan ng promissory note, vouchers, coupons, tokens, tickets, cheats, or any object other than the legal tender o other than cash o yung legal tender natin is peso. The corresponding amount in peso. Kahit pa hilingin daw yan ng employee. Article 103, sabi rito, wages shall be paid at least once every 2 weeks. Ito yung sinasabing kinsenas katapusan, ano? Once every 2 weeks. Okay? Sabi, payment of wages of employees engaged to perform a task which cannot be completed in 2 weeks shall be subject to the following conditions. So kung hindi daw matapos yung task in 2 weeks, sabi rito that payments are made at intervals not exceeding 16 days in proportion to the amount of work completed. So, kinsenas katapusan pa rin. Okay? Tapos, pangalawa, the final settlement is made upon completion of work. Okay? Okay. So, yun. Punta naman tayo sa Article 106, Contractor or Subcontractors. Tingnan natin. Sabi rito, whenever an employer enters into a contract with another person for the performance of the former's work, the employees of the contractor and of the latter's subcontractor, if any, shall be paid in accordance with the provisions of the code. Okay. Sabi niya rin, there is labor-only contracting where the person supplying workers to an employer does not have substantial capital or investment in the form of tools, kundi ang labor only pagka nagpo-provide lamang siya ng labor o yung kanyang pagod, ano? Punta naman tayo sa indirect employer, posting a bond. Ito mahalaga to, Article 108, posting of bond. An employer or indirect employer may require the contractor or subcontractor to furnish a bond equal to the cost of labor under contract on condition that the bond will answer for the wages due the employees should the contractor or subcontractor, as the case may be, fail to pay the same. So, dapat nga ang usapan, kunwari ako, nagpagawa ako ng bahay sa isang contractor, gawin niya muna yung 50% ng bahay. Sa kanya ako singilin nung halaga na yon. Pagtapos niya na yung proyekto, nung ko siya bibigyan ng buong bayad. Ito namang bond na ito, posting amount, iba naman to. Sinisiguro lamang nito na mapapasweldo yung mga tauhan. Ano? So ano ba yung indirect employer? Nabanggit rito kasi indirect employer, the provisions of the immediately preceding article shall likewise apply to any person. Ito siya, any person, partnership, association, or corporation which, not being an employer, contracts with an independent contractor for the performance of any work, task, job, or project. So, ang indirect employer, kunwari ako, tao ako ng agency, security agency. Tapos, kunwari, yung ganitong school na kailangan ng security guard. So, sila yung aking indirect employer. Pero, ang employer ko talaga yung agency. Okay. Okay. Ano pa bang mga ibang mahalaga? Ito tungkol sa sweldo na lahat ito eh. Pero wala naman ng ito. Article 122. Creation of regional tripartite wages and productivity boards. So ito meron daw ginagawang ganito. Ito yung regional boards sa lahat ng regions. Kasama daw yung autonomous regions as may be established by law. Ito ang kanilang powers. Kaya natin binabasa ito kasi mahalaga ito sa ating kaalaman. Di ba nabanggit kanina sila nagtatakda ng minimum wage. So basahin natin yung kanilang powers and functions. Ito ng regional tripartite wages and productivity boards. Letter A, to develop plans, programs, and projects relative to wages, incomes, and productivity improvement for the respective regions. B, to determine and fix minimum wage rates applicable in the regions, provinces, or industries therein. C, to undertake studies, researches, and surveys necessary for the attainment of their functions. D, coordinate with the other regional boards as may be necessary to attain policy and intention of this code. E, to receive, process, and act on applications for exemption from prescribed wage rates as may be provided by law or any wage order. And F, to exercise such other powers and functions as may be necessary. Ano man daw yan, basta necessary yan para matugunan nila yung kanilang obligasyon sa batas. Okay? O mandate, yung mandato nila under this, dito sa binabasa nating labor code. Okay? Wala pa tayo sa kalahati, ano? O ito, merong standards or criteria for minimum wage fixing. Merong mga standards na nakalagay dito sa labor code. Ito na naman, administration and enforcement, chapter 6 naman tayo. Ang chapter 6 ay nagsisimula sa article 128 o yung visitorial and enforcement power. So ito meron ng ganito tayong nabasa kanina na ang Secretary of Labor at ang kanyang mga representatives ay merong access to employers' records at any time. Meron ding ganong provision na naman dito. Parang naulit lang. Parang nire-enforce niya lang yung provision na yun. Okay. Punta tayo rito. Title 3. Working Conditions for Special Groups of Employees. Ito yung Article 130. Nagsisimula yung Employment of Women. Yung Chapter 1 ng Working Conditions for Special Groups of Employees. Nagsisimula siya sa Article 130. Ito yung night work prohibition. Sabi rito, no woman regardless of age shall be employed or permitted or suffered to work with or without compensation in any industrial undertaking or branch thereof between 10 at night and 6 o'clock in the morning of the following day. Bawal daw yun. Parang sa mga patay hindi naman yata. B, any commercial or non-industrial undertaking or branch thereof other than agricultural between midnight and 6 o'clock in the morning of the following day. And letter C, in any agricultural undertaking at night time unless she is given a period of rest of not less than 9 consecutive hours. Bawal daw yun Pero may exception kasi, sabi rito, similar na naman yon. sa mga exception. Tandaan natin yung may emergency, yung mga fortuitous event, serious accident, yan. Case of urgent work sa mga machineries, kapag daw yung trabaho ay necessary to prevent serious loss ng mga nabubulok o yung mga perishable groups, where the woman employee holds a responsible position of managerial or technical nature, where the nature of work requires the manual skill and dexterity of women workers at hindi ito magawa ng mga kalalakihan, where the women employees are immediate members of the family operating the establishment or undertaking, and under other analogous cases, yung mga similar cases na sinasabi ng Secretary of Labor and Employment na pwede nating anuhin yung women, pwede natin silang obligahin. So kahit ngayon ko lang napansin, kahit pala sa labor code, meron ng ibang pagtatangi ang batas para sa mga kababaihan. Kailangan din, Article 132, merong facilities for women. Dapat meron silang seats na naaayon sa kanila. Yan, meron silang upuan, meron silang separate toilet rooms and lavatories, meron silang nursery in a workplace for benefit of the women employees, ay mga nagpapasuso, ganyan. And to determine appropriate minimum age and other standards for retirement or termination in special occupations. Article 133, may maternity leave benefits, pero maaaring na supersede na ito ng yung Magna Carta for Women. Maaaring ang tingin ko meron ng special laws na para dito. Pero basahin na rin natin na sinasabi na bawal ang diskriminasyon. Bawal sweldohan na mas mababang sweldo ang babae kaysa sa lalaki na pareho naman yung ginawa nilang work value. Sabi rin dito, Article 136, stipulation against marriage, it shall be unlawful for an employer to require as a condition of employment or continuation of employment na ang isang babae ay hindi magpakasal o sabihin niya expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated or to actually dismiss, discharge, discriminate, or otherwise prejudice o basta perwisyuhin mo yung babae dahil lamang siya ay kinasal. Bawal po yun, ha? Article 136. Naalala ko, naitanong ko yan sa dati kong teacher na abogado. Bawal po yan. Okay? Article 137, sinasabi niya naman na bawal daw sa isang employer to deny any woman employee benefits. Bawal daw yan. Bawal to discharge such woman on account of her pregnancy. Bawal yan. Bawal din to discharge or refuse the admission of such woman upon returning to her work for fear that she may again be pregnant. Bawal yun. Porque nabuntis, iisipin mo, baka mabuntis ulit, huwag na natin tanggapin. Bawal yun. Basta may babae, may karapatan. Article 138, classification of certain women workers. Sabi rito, any woman who is permitted or suffered to work with or without compensation in any nightclub, cocktail lounge, massage clinic, bar, similar establishments under the effective control or supervision of the employer for a substantial period of time determined by the Secretary of Labor shall be considered as an employee. Yung mga nasa nightclub, sila ay kinoconsider na empleyado. Parang medyo conflict ito dun sa isang sinabi kanina na mga babae ay hindi dapat pagtrabahuhin sa pagitan ng alas 10 ng gabi at alas 6 ng umaga. Pero sinabi naman dito, yung mga nagtatrabaho sa nightclub, massage clinic, cocktail lounge ay kinokonsiderang empleyado. Chapter 2 na nagsisimula sa Article 139, minimum employable age. Sabi rito, no child below 15 years of age shall be employed except when he works directly under the sole responsibility of his parents or guardian and his employment does not in any way interfere with his schooling. Tandaan yan, ha? O kaya yung mga artista, kasama nila yung mga nanay nila o yung mga legal guardian nila, kahit minor de edad sila, okay lang yun. At ito, meron silang any person between 15 and 18 years of age may be employed for such number of hours as determined by Secretary of Labor. Okay. O kaya, tapos, letter C, the foregoing provision shall in no case allow the employment of a person below 18 in an undertaking which is hazardous or deleterious in nature as determined by the Secretary of Labor. Kaya napapansin nyo rito, no children has been harmed sa paggawa ng pelikulang to, or sasabihin, ang mga batang ito ay, ang mga children na empleyado sa pelikula o show na ito ay merong permiso ng Department of Labor and Employment. Ayun po yun, kasi may provision sa employment of minors. Now, Chapter 3, Employment of House Helpers. Hindi na po natin babasahin yan. Siguro babasahin natin yan sa ibang pagkakataon kasi meron ng kasambahay law. So, yung provision sa labor code tungkol sa mga house helpers ay hindi na po masusunod at masusunod na yung kasambahay law. Okay? 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 Ano pa ibang mahalaga ba na kailangan natin? Ito. Occupational Health and Safety. Article 162, Safety and Health Standards. Sabi nga, the Secretary of Labor and Employment shall by appropriate orders set and enforce mandatory occupational safety and health standards to eliminate or reduce occupational safety and health hazards in the workplace at magtalaga ng bago at modernong pamaraan na masiguro yung kaligtasan ng mga manggagawa. Okay. Okay, ano pa ba? Okay, ito naman yung Title 2, Employees Compensation and State Insurance Funds. So, basahin na rin natin ng konti para sa kaalaman ninyo. Total, diniscuss ko na ito. Sabi sa Article 166, the state shall promote and develop a tax-exempt employees compensation program. Kung kaya meron pong mga empleyado, merong mga korporasyon na nagbibigay sila ng package na tax-exempt, retirement package na tax-exempt para sa mga empleyado. Article 167, ito yung definition of terms. Sabi rito, yung code means the Labor Code of the Philippines. Commission means the Employees Compensation Commission. SSS means Social Security System. GSIS means Government Service Insurance System. System means SSS or GSIS, as the case may be. Employer means any person, natural or juridical, employing the services of the employee. Employee, alam na natin yan, yung mga means any person compulsory covered by the GSIS law. Yan, para sa kaalaman natin. Okay? Itong mga definition na to ay para lang nililinaw niya kung paano ginagamit yung terms dito sa policy and definitions sa Title 2. Ito, pinag-usapan natin dito yung employees compensation. Okay? Dependent means the legitimated or legally adopted or acknowledged natural child who is unmarried, not gainfully employed, not over 21 years of age. Beneficiaries naman yung mga dependent spouse unless he or she remarries, and dependent children who are primary beneficiaries. Injury means harmful change in the human organism from an accident arising out of the course of employment. So kung na-aksidente ka dahil sa pagtatrabaho mo, yun yung injury na tinutukoy dito. Sickness, ganun din. Illness naman siya na nangyari sa'yo dahil na-expose ka sa hazardous condition sa iyong trabaho. Death means loss of life resulting from injury or sickness. Disability means loss or impairment of a physical or mental function resulting from injury or sickness. So, marami pang ibang terms pero tingin ko alam na natin yan. Okay? Coverage and liability, hindi ko nababasahin yan. Kasi usually, hindi ako sure kung meron ng special law. Yung GSIS law yata, mga contribution, medical benefits, disability benefits. Ayan, okay.
Punta ko lang hanggang dito ha.
Okay. Okay, ano pa ba yung Ano pa ba yung Medicare? Yan, ngayon sa atin, PhilHealth. Yan, magkakaroon na ng PhilHealth law, so hindi ko na babasahin to. Hopefully, magtuloy-tuloy na lahat ng Pilipino ay magkaroon ng compulsory coverage ng PhilHealth, ano? So marami tayong ano. Okay. Ano pa yung mga babasahin natin? Ito. Aha. Ito mahalaga to. National Labor Relations Commission. Chapter 1, Creation and Composition. Nagsisimula siya sa Article 213. Yan, National Labor Relations Commission. There shall be a national NLRC, yan, which shall be attached to the Department of Labor and Employment for program and policy coordination only. Ito po ay binubuo ng chairman and 14 members. Yan yung NLRC. Okay, ano pa ba yan? Okay. 5 members each shall be chosen from among the nominees of the workers and employers organizations respectively. The chairman and the 4 remaining members shall come from the public sector, with the latter to be chosen from among the recommendees of the Secretary of Labor and Employment. Okay. Okay, ayan. Huwag natin basahin yan. Sila-sila lang yan. Okay. Ito, yung Article 214, Headquarters, Branches, and Provincial Extensions. Sabi rito, the Commission and its 1st, 2nd, and 3rd Divisions shall have their main offices in Metropolitan Manila. 4th and 5th sa Cebu and Cagayan de Oro. Commission shall establish as many regional branches as there are regional offices of the DOLE, sub-regional branches, or provincial extension units. There shall be as many labor arbiters as may be necessary for the effective and efficient operation of the Commission. Each regional branch shall be headed by an executive labor arbiter. Meron din mga kwalifikasyon dito. Sabi rito, the chairman and the other commissioners shall be members of the Philippine. Kailangan abogado raw. Tapos engaged sila in the practice of law for at least 15 years. At kailangan meron ka 5 years experience or exposure in the field of labor management relations, and shall preferably be residents of the region where they are to hold office. Ayan, kailangan pala abogado ha pagka member ka nitong National Labor Relations Commission. Okay. Ano naman yung kapangyarihan nito? Ito, mahalaga ito. Mahalaga yung powers and duties. Article 217, Jurisdiction of the Labor Arbiters and the Commission. Sabi niya rito, except as otherwise provided under this code, the labor arbiters shall have original and exclusive jurisdiction to hear and decide within 30 calendar days after the submission of the case by the parties for decision, without extension, even in the absence of stenographic notes, the following cases involving all workers, whether agricultural or non-agricultural. So itong mga labor arbiter na ito, kapag ka ipinasa na sa kanila ang case for decision at hindi na nag-motion for extension, kahit na wala pa raw stenographic notes, basta submitted for decision, kailangan na nila itong desisyonan within 30 calendar days. Di ko alam kung may pagbabago doon, pero yun na nakasaad sa labor code. Ano yung mga kasong yon? Unfair labor practice cases, termination disputes. If accompanied with a claim for reinstatement, those cases that workers may file involving wages, rates of pay, hours of work, and other terms and conditions of employment. Claims for actual, moral, exemplary, and other forms of damages arising from the employer-employee relations. Cases arising from any violation of Article 264 of this code, including questions involving the legality of strikes and lockouts, and ika-6, except claims for employees' compensation, Social Security, Medicare, and maternity benefits. Hindi kasama daw yung claims ng Social Security, pero all other claims arising from employer-employee relations, including those of persons in domestic or household service. Hindi ko lang alam kung applicable pa to kasi may kasambahay law na nga. Involving an amount exceeding 5,000 pesos. Basta daw lumagpas ng 5,000 pesos yung claims, regardless of whether accompanied with a claim for reinstatement. So kahit may kasama pa yung claim for reinstatement o claim lamang yan ng halaga na lalagpas sa 5,000 piso, kailangan nila itong aksyonan. Letter B. The Commission shall have exclusive appellate jurisdiction over all cases decided by labor arbiters. Letter C. Cases arising from the interpretation or implementation of collective bargaining agreements and those arising from interpretation or enforcement of company personal policies shall be disposed of by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. Okay. Powers of the Commission. Ano yung kapangyarihan ng National Labor Commission? Sabi niya, to promulgate rules and regulations governing and hearing and disposition of cases before it and its regional branches, as well as those pertaining to its internal functions, and such rules and regulations as may be necessary to carry out the purposes of this code. To administer oaths, summon the parties to a controversy, issue subpoenas requiring the attendance and testimony of witnesses or the production of such books, papers, contracts, records, statement of accounts, agreements, and others as may be material to a just determination of the matter under investigation, and to testify in any investigation or hearing conducted in pursuance of this code. Letter C. To conduct investigation for the determination of a question, matter, or controversy within its jurisdiction, proceed to hear and determine the disputes in the absence of any party thereto who has been summoned or served with notice to appear, conduct its proceedings or any part thereof in public or in private, etc. Ang dami. Letter D. To hold any person in contempt directly or indirectly and impose appropriate penalties, therefore in accordance with law. Ang dami lang kapangyarihan. Letter E. To enjoin or restrain any actual or threatened commission of any or all prohibited or unlawful acts, or to require the performance of a particular act in any labor dispute, if not restrained or performed forthwith, may cause grave or irreparable damage to any party, or render ineffectual any decision in favor of such party. So napakarami niyan, napakarami lang powers. May kapangyarihan sila ng ocular inspection, Article 219, compulsory arbitration sa Article 220. They have the power, sabi rito sa Article 220, the power to ask the assistance of other government officials and qualified private citizens to act as compulsory arbitrators on cases referred to them, and to fix and assess the fees of such compulsory arbitrators, taking into account the nature of the case, the time consumed, etc., etc. Ayan, ha? Okay, ano pa ba? Appeal. Dito tayo sa appeal. So, kung kunwari, nagpunta ka sa NLRC, sabi rito, Article 223, decisions, awards, or orders of the labor arbiter are final and executory unless appealed to the commission by any or both parties within 10 calendar days from receipt of decision. So, pag natanggap mo na yung desisyon, yung awards or orders, pwede kang umapila sa loob ng 10 calendar days. Pag sinabi pong 10 calendar days, hindi kasali yung unang araw, pero kasali yung yung huling araw. Kunwari, tanggap ko ngayon, 1 ngayon. 10 calendar days. Hindi kasaling 1, natanggap ko siya ngayon. Ang bilang ko is 2, 3, 4, 5, 6, 7, 8, 9, 10. So, 10 calendar days, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So, natanggap ko ngayon, sa 11 po, ang tawag dito, ang due, okay, ng aking pagsusumite ng appeal. Okay? So, kung bumagsak naman po ito, isa sa mga araw na yun, kunwari, bago mag 11, 10, Sunday, o di sa 11 11 Sunday, o di pwede pa ako, Friday, kunwari, ang 11. Nagkakamali ako ng example. So, kunwari, holiday, yung ikasampung araw mo ay holiday, or yung ikasampung araw mo ay tumapat ng Sabado, Linggo, sa Lunes, kasama pa yun. Yun po ang paliwanag dyan, ha? Okay? Sabi rito, ito yung mga grounds for appeal. Ito lamang. A, if there is prima facie evidence of abuse of discretion on the part of labor arbiter. B, if the decision, order, or award was secured through fraud or coercion, including graft and corruption. C, if made purely on questions of law. Meron ka mga katanungan tungkol sa batas. Okay? And D, if serious errors in the findings of facts are raised which would cause grave or irreparable damage or injury to the appellant. So, yung pong apat na nabanggit, ang mga dahilan mo para ikaw ay umapila. Yan, ha? So, medyo malapit na tayo matapos. Hinahanap ko na lang yung mga importante rito, ha? Meron pa dito, labor organizations. So, mamaya, babalikan natin yung labor organizations. Magtitimpla lang ako ng kape ko. Huwag kayong aalis. Naalala ko tuloy na nagraradyo pa ako. Inaabot din ako ng 2 hours. Pag may kasunod ako ng programa, 4 hours. Kaya ko to. Kaya alis. Okay. So ako'y nagbabalik para hopefully matapos na natin itong labor code, ano? Or at least hindi man buo, yung mahahalaga lamang na provision. So, yan, para sama-sama nating alamin mga kapwa ko layman. Okay? Ito po, Title 4, Labor Organizations. Ito po Chapter 1, Registration and Cancellation. So sabi sa Article 234, Requirements of Registration, any applicant, labor organization, association, or group of unions or workers shall acquire legal personality and shall be entitled to the rights and privileges granted by law to legitimate labor organizations upon issuance of the certificate of registration based on the following requirements. Number 1, yung corresponding registration fee, nakalagay dito 50 pesos. Hindi ko alam kung ganun pa rin. B, name of its officers, their addresses, the principal addresses of the labor organization, the minutes of the organizational meetings, and the list of the workers who participated in such meetings, the names of all its members comprising at least 20% of all the employees in the bargaining unit where it seeks to operate. Letter D, if the applicant union has been in existence for 1 or more years, copies of its annual financial reports, and letter E, 4 copies of the Constitution and bylaws of the applicant union, minutes of its adoption or ratification, and the list of the members who participated in it. Yun ha. So yun daw yung pag-register ng labor organization. Article 235, yung Bureau shall act on applications for registration within 30 days. So pag nag-file ka, upon filing, within 30 days, actionan po yan ng Bureau. Okay? Pwede ka rin daw umapila. Pag na-deny ka, sabi, the decision of the Labor Relations Division in the regional office denying your registration may be appealed by the applicant union within 10 days from receipt. So, na-deny ako ngayon, ako yung applicant. Within 10 days, pwede ako mag-apila. Okay? Ano pa ba mahalaga rito? Cancellation of registration. Pwede mo rin i-apila daw, sabi. Article 239, sinasabi niya naman, ano ba yung grounds para makansela for the cancellation of union registration? Ito, madami-dami. Misrepresentation, letter A. Misrepresentation, false statement, or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification. Letter B, failure to submit the documents mentioned in the preceding paragraph within 30 days from adoption or ratification of the Constitution and bylaws or amendments thereto. C, misrepresentation, false statements, or fraud in connection with the election of officers, minutes of the election of officers, the list of voters, or failure to submit these documents together with the list of the newly elected or appointed officers and their postal addresses within 30 days from election. Letter D, failure to submit the annual financial report to the Bureau within 30 days after the closing of every fiscal year, and misrepresentation, false entries, or fraud in the preparation of the financial report itself. Letter E, acting as a labor contractor or engaging in the cabo system or otherwise engaging in activity prohibited by law. Okay? 6, or letter F, entering into collective bargaining agreements which provide terms and conditions of employment below minimum standards established by law. G, asking for or accepting attorney's fees or negotiation fees from employers. Bawal yun. H, other than for mandatory activities under this code, checking of special assessments or any other fees without duly signed individual written authorizations of the members. I, failure to submit list of individual members to the Bureau once a year or whenever required by Bureau. And 10 or letter J, failure to comply with requirements under Articles 237 and 238. Okay? 238, yung cancellation, nabasa natin yan. 237 naman, ang sinasabi sa requirements sa 237, proof of the affiliation of at least 10 locals or chapters, each of which must be duly recognized collective bargaining agent in the establishment or industry in which it operates, supporting the registration of such applicant, federation, or national union, and the names and addresses of the companies where the locals or chapters operate, and the list of all the members in each company involved. Okay? So, yun yung mga grounds for cancellation of union registration. Ayan ha. Ito naman yung, ito para sa mga union na ito no? Ito naman, rights and conditions of membership. Article 241 siya nagsisimula. Sabi rito, ito yung mga karapatan at kondisyon of membership in a local organization. Parang marami rin to Ay, ang dami ng putragis. Charot. Basahin na rin natin. Sabi niya rito, no arbitrary or excessive initiation fee shall be required of the members of a legitimate labor organization, nor shall arbitrary, excessive, or oppressive fine and forfeiture be imposed. Number 2, members shall be entitled to full and detailed reports from their officers and representatives of all financial transactions as provided for in the Constitution and bylaws of the organization. 3, the members shall directly elect their officers, including those of the national union or federation to which they or their union is affiliated, by secret ballot at intervals of 5 years. No qualification requirements for candidacy to any, wala daw qualification requirements. The members shall determine by secret ballot after due deliberation any question of major policy affecting the entire membership of the organization. Letter E, no labor organization shall knowingly admit as members or continue in membership any individual who belongs to a subversive organization. So, bawal sana yung mga members ng subversive organizations, no? Yung mga radikal, yung mga nanggugulo, bawal. Number 7, no person who has been convicted of a crime involving moral turpitude shall be eligible for election as a union officer or for appointment to any position in the union. Dapat hindi pwedeng ma-elect o magkaroon ng posisyon sa union yung isang miyembro na na-convict na ng moral turpitude. So, tingnan natin nga, ano ba yung moral turpitude na yan? Ano ba yan? Research natin tingnan natin. Okay. Ang hirap puro mga jurisprudence. Hahanapin mo pa. Babasahin mo pa yung mga Tingnan natin ito. Sabi rito, ito yung mga crimes involving moral turpitude: adultery, concubinage, rape, arson, evasion of income tax, baratry, bigamy, blackmail, bribery, criminal conspiracy to smuggle opium, or siguro sa ngayon, shabu na o kahit na anong prohibited drugs, dueling, nakalagay yung iba rito sa revised penal code, embezzlement, extortion, forgery, libel, making fraudulent, teka, naputol haba-haba naman ito. Hanapin ko pa sa isang case. O basta at least may idea na tayo ng crimes involving moral turpitude. Okay? least naunawaan na natin siya. Kaya nyo minsan, sa ibang live ko regarding dito sa layman's terms, ito try nating magkwento o magbasa ng mga kaso, yung mga jurisprudence na tinatawag, okay, na may connection sa anumang sangay ng batas na meron tayo. Okay, ay nasa na ako, ituloy natin siya. Ito, making fraudulent proof of loss on insurance contract. Tuloy natin. Mutilation of public records, fabrication of evidence, offenses against pension laws, perjury, seduction under the promise of marriage, estafa, falsification of public document, and estafa through falsification of public document. Yun ang sinasabing mga krimen under moral turpitude. Okay. Ito yung mga may problema ka siguro sa iyong standard of justice, honesty, and good morals. Yun yung mga uri ng krimen. Okay? So, bawal silang ma-elect as a union officer. Bawal din silang ma-appoint. O, punta na tayo. G. No officer, agent, or member of a labor organization shall collect any fees, dues, or other contributions in its behalf or make any disbursement of its money or funds unless he is duly authorized pursuant to its constitution and bylaws. Naintindihan na siguro natin. H, saan ba ako? H pala ito, pang number 8. Every payment of fees, dues, o lahat doon ng pagbabayad shall be evidenced by a receipt. 9, or letter I, the funds of the organization shall not be applied for any purpose or object other than those expressly provided by its constitution and bylaws. Okay, yun lang yung purpose. Hindi pwedeng ipang-good time natin yung union dues. Okay. Number 10, every income or revenue of the organization shall be evidenced by a record. So, record showing its source, expenditure of the funds, and to whom the payment is made, yung date, place, and purpose of such payment para malinaw. Okay. The officers of any labor organization shall not be paid in any compensation other than the salaries and expenses due to their positions as specifically provided for in its constitution and bylaws. Yun lamang po, wala nang iba. And lastly na nga ba ito? Hindi pa pala. Okay, 11, L, or number 12, the treasurer of any labor organization shall render to the organization and to its members a true correct account. Bawal yung kurakot na treasurer, ha. Magbibigay siya ng account at least once a year within 30 days after the closing of its fiscal year, at such other times as may be required by a resolution of the majority of the members and upon vacating his office. Para malinaw kung saan napunta yung mga pera. Siyang kurakot, pwedeng kasuhan, ha. Letter M, the books of accounts and other records of financial activities ng kahit na anong labor organization shall be open to inspection by any officer or member during office hours. Ano ba yung office hours? 8 to 5. Yun ang pagkakaalam ko, ha. Sabi pa rito, no special assessment or other extraordinary fees may be levied or may be collected upon the members unless authorized by a written resolution. Dapat laging may written resolution lahat ng pagkolekta ng pera at malinaw kung saan ito napupunta. Letter O, other than for mandatory activities under the code, no special assessments, attorney's fees, negotiation fees, or any other extraordinary fees may be checked off from any amount due to an employee without an individual written authorization duly signed by the employee. The authorization should specifically state the amount, purpose, and beneficiary of the deduction. And lastly, letter P. It shall be the duty of any labor organization and its officers to inform its members on the provisions of its constitution and bylaws, collective bargaining agreement, the prevailing labor relations system, and all their rights and obligations under existing labor laws. Okay? Tandaan natin, yan yung mga yung mga nabanggit natin pagkarami-rami, yan yung rights and conditions of membership in a labor organization. Ano yung karapatan ng mga lehitimong labor organization? Ito yung mga karapatan nila. Article 242. Letter A. To act as the representative of its members for the purpose of collective bargaining. B. To be certified as the exclusive representative of all employees in an appropriate bargaining unit for purposes of collective bargaining. Letter C. To be furnished by the employer upon written request with its annual audited financial statements, including the balance sheet and the profit and loss statement, within 30 calendar days from the date of receipt of the request, after the union has been duly recognized by the employer or certified as the sole and exclusive bargaining representative of the employees in the bargaining unit, or within 60 calendar days before the expiration of the existing collective bargaining agreement or during the collective bargaining negotiation. Letter D. To own property, real or personal, for the use and benefit of the labor organization and its members. Parang isang korporasyon din na pwedeng may-ari ng real or personal property. Letter E. To sue and be sued in its registered name. Pwede siyang manghabla o pwede rin siyang ihabla. And letter F. To undertake all other activities designed to benefit the organization and its members, including cooperative, housing, welfare, and other projects not contrary to law. Okay? Okay. Nakapagod ito, ha? Okay. Next. Okay, so basahin natin yung Title 5 or yung coverage. Sabi rito, Article 243, all persons employed in commercial, industrial, and agricultural enterprises and in religious, charitable, medical, or educational institutions, whether operating for profit or not, shall have the right to self-organization to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining. Okay? Article 243. Ito yung basihan kung bakit tayo nagagawa ng mga labor unions. Article 244. Right of employees in the public service. So under the Corporation Code, shall have the right to organize and bargain collectively with their respective employers. Ito yung mga empleyado ng government corporations, ha? Pwede rin sila. Article 245. Ineligibility of managerial employees to join any labor organization. Right of supervisory employees. Sabi rito, hindi eligible mag-join ang managerial employees at di sila eligible mag-assist o bumuo ng anumang labor organization. Ganun din ang supervisory employees. Pero ang supervisory employees ay pwedeng mag-assist, sumali, or form separate labor organizations of their own. So malinaw po, hindi lang pwedeng bumuo, mag-assist, mag-join managerial employees. Ang supervisory employees, hindi lang sila pwedeng sumali sa labor organizations ng rank and file employees. Pero pwede silang mag-join, assist, at bumuo ng sarili nila para sa mga supervisory employee. Okay, ano pa ba? Ayun. Dami na tayo na-cover dito. Unfair labor practices. Dito tayo sa Title 4. Ang konsepto niya ay unfair labor practices violate the constitutional right of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including the right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect. So yun po ang konsepto ng unfair labor practice under Article 247. Tignan natin tong Chapter 2. Ito yung unfair labor practices ng employers. Ano ba ito? Article 248, number 1. To interfere with, restrain, or coerce employees in the exercise of their right to self-organization. Number 2. To require as a condition of employing that a person or an employee shall not join a labor organization. Bawal daw sabihin na, oy, tatanggapin kita sa trabaho basta hindi ka kasali o hindi ka sasali sa union o sa labor organization. Number 3. To contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their... Bawal daw yun. Letter D. To initiate, dominate, assist, or otherwise interfere with the formation or administration of any labor organization, including the giving of financial or other support to it or its organizers or supporters. Yan ha. Number 5. To discriminate in regard to wages, hours of work, and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. Bawal yun. To discriminate, ha? Lalo na pagdating sa sahod. Sasabihin niya, bawasan ko yung sahod mo kasi member ka ng union o ng labor organization. 6. To dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code. Bawal yun. Letter G. To violate the duty to bargain collectively as prescribed by this code. Bawal. H. To pay negotiation or attorney's fees to the union. Oy, rotate sana siya. Nasaan na ako? To pay negotiation or attorney's fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other dispute. And lastly, letter I or number 9, to violate a collective bargaining agreement. Mahalaga po na sundin kung ano yung napagkasunduan. Okay? Ito naman, mahalaga rin ito. Unfair labor practices of labor organizations. Ito naman yung mga pwedeng gawin na kasalbahihan ng mga labor organizations. Article 249, number 1. To restrain or coerce employees in the exercise of the rights of organization. However, a labor organization shall have the right to, with respect to the acquisition or retention of membership. Letter B or number 2. To cause or attempt to cause an employer to discriminate against an employee, including discrimination against an employee with respect to whom membership in such organization has been denied. So basically common sense, yung pang-discriminate o pang-coerce, bawal yun, yung mang-iengganyo ka na tara, mag-self-organization tayo, pero hindi naman talaga, hindi naman sang-ayon sa batas, o kaya sasabihin mo sa employee, sige, pag-inita mo yan, boss, at hindi namin sinali yan eh. Or number 3, letter C, to violate the duty or refuse to bargain collectively with the employer provided it is the representative of the employees. Letter D, to cause or attempt to cause an employer to pay or deliver or agree to pay or deliver any money or other things of value in the nature of an exaction for services which are not performed or not to be performed, including the demand for fee for union negotiations. 5, letter E, to ask for or accept negotiation or attorney's fees from employers as part of settlement of any issue in collective bargaining or any other dispute. And lastly, to violate a collective bargaining agreement. Halos pareho lang din. So kailangan po sundin yung collective bargaining agreement at hindi gamitin yung karapatan para mang-abuso o may pag-initan ka. Yun lamang naman po ang mahalaga dito na tandaan natin eh. Tayong mga ordinaryong tao, tayong mga hindi naman tayo mga abogado, yun lang yung kailangan nating maintindihan. Kung titignan natin yung konsepto niya, lahat siya is about justice, fair play, Hindi ba? About gamitin mo ng naaayon sa batas yung iyong samahan. Ganon din ang mga employer naman, sumunod ka sa batas. Basically, ganun eh. Huwag kang mag-coerce, huwag mong pag-initan yung isang empleyado, di ba? O ito naman, mahalaga lang to kasi tungkol ito sa grievance machinery and voluntary arbitration. Article 260. The parties to a collective bargaining agreement, yung employer ito, at saka yung labor group, shall include therein provisions that will ensure the mutual observance of its terms and conditions. Kailangan nilang mag-establish o bumuo ng isang makinarya o yung tinatawag nating grievance machinery for the adjustment and resolution of grievances arising from the interpretation or implementation of their collective bargaining agreements. So kung may pagtatalo sa interpretasyon sa kanilang pagkakasunduan, lalabas si grievance machinery. So lahat ng grievances, lahat ng problema ay isusumite sa grievance machinery, which so lahat daw ng sinumite sa grievance machinery na hindi naayos within 7 calendar days from the date of its submission shall automatically be referred to voluntary arbitration na kung voluntary arbitration prescribed in the collective bargaining agreement. So grievance machinery, and then pag hindi naayos doon, eto mga partido na to ay magde-designate sila ng voluntary arbitrator or panel of voluntary arbitrators. Okay? So, kinukuha itong mga arbitrators na to ay yung mga tagapagitna. Kinukuha ito sa duly accredited na sa mga sa listahan ng mga qualified voluntary arbitrators na accredited ng board. Okay? Sineselect ito ng mga parties. So, grievance machinery and voluntary arbitration. Okay, ano bang jurisdiction naman itong mga voluntary arbitrators na to? They shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the CBA and those arising from interpretation or enforcement of company personnel policies referred to in the immediately preceding article. Okay? So, yun lang naman ang kailangan nating tandaan. Yun lang ang kailangan nating matandaan. Ano pa ba? O, ito. Sa mga manggagawa. Title 8. Strikes and lockouts. Mamaya pag-usapan natin. Magbe-break muna ako ulit. Ang dami ko ng break. Ang hirap-hirap i-discuss nito pero matatapos na natin ang labor code. Sa nakaka3 oras na tayo. Mamaya babalik ako. So, ako'y muling nagbabalik para sa programang In Layman's Terms. Ayan para pag-usapan na naman natin. Tuloy natin tong labor code Imagine, parang isang buong semester sa law school. Kahit pa paano may idea na tayo sa nalalaman ng mga law students kahit na tayo ay mga ordinaryong tao lamang o hindi tayo mga eksperto sa batas, di ba? Okay, pag-usapan na natin itong Title 8, Strikes and Lockouts and Foreign Involvement in Trade Union Activities. Sabi ito sa 263, Article 263, Strikes, picketing, and lockouts. It is the policy of the state to encourage free trade unionism and free collective bargaining. Okay, workers shall have the right to engage in concerted activities for purposes of collective bargaining for their mutual benefit and protection. Karapatan daw ng isang lehitimong labor organization to strike and picket, and karapatan naman ng employers na mag-lockout. Pero kailangan alinsunod ito lagi sa national interest. Okay? Pangatlo naman, in case of bargaining deadlocks o yung parang sa chess, parang stalemate, the duly certified or recognized bargaining agent may file a notice of strike, or the employer may file a notice of lockout with the ministry at least 30 days before the intended date thereof. In cases of unfair labor practice, the period of notice shall be 15 days, and in the absence of a duly certified or recognized bargaining agent, the notice of strike may be filed by any legitimate labor organization in behalf of its members. However, in case of dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which may constitute union busting where the existence of the union is threatened, the 15-day cooling off period shall not apply, and the union may take action immediately. Medyo hindi ko rin siya ganong naunawaan. Siguro papakinggan ko na lang ulit yung mga sinabi ko rito. Pero tignan natin kung ano bang kahulugan ng union busting. Hindi ko naiintindihan Union busting. Ano ba ang kanyang kahulugan? Sandali sandali. Ano ibig sabihin ng union busting? Ayun na naman, pag naghahanap ka ng may kinalaman sa batas, laging jurisprudence o yung mga kasong mahahaba. Tapos hanapin mo pa, rather than hanapin mo na lang union busting definition. Ito na lang Wikipedia. Sabi rito, union busting is a range of activities undertaken to disrupt or prevent the formation of trade unions or their attempts to grow their membership in a workplace. Parang sinisira mo yung union. Attempt na wag na silang lumawig pa, o ikaw ay mapakialaman mo sila, di ba? Para hindi na sila lumaki pa, o ma-prevent mo, di ba? To disrupt or prevent the formation of trade unions, yun sabi. Okay, so letter D naman, the notice must be in accordance with such implementing rules. Ito yung notice daw ng strike o notice of lockout. Siyempre, bibigay ka muna ng abiso na kami ay magsa-strike o kami ay magla-lockout. Kailangan daw alinsunod siya sa implementing rules and regulations. Hindi naman pa pwedeng hindi siya alinsunod sa batas, di ba? Sabi naman dito, during the cooling off period, it shall, parang nag-break, may cool off. It shall be the duty of the ministry to exert all efforts at mediation and conciliation to effect a voluntary settlement. Tayo naman. Letter E yun. F, a decision to declare a strike must be approved by a majority of the total union members in the bargaining unit concerned. May secret ballot yan para malaman mo kung makukuha mo ba yung majority bago ka mag-strike. Okay. Sabi naman dito, letter G, pagka when, in his opinion, there exists a labor dispute causing or likely to cause a strike or lockout in an industry na indispensable to the national interest, kunwari pagkain, yung Secretary of Labor may assume jurisdiction over the dispute at siya na lang ang magde-decide roon. Okay? Siya ang magde-decide and to certify the same to the Commission for compulsory arbitration. Okay? Kasi mahalaga hindi ka pwedeng mahalaga ito, makakasira ito sa national interest, parang ganon. Lalo na mahalagang industriya, kunwari mga jeepney drivers at saka bus drivers, di ba? Letter H, before or at any stage of the compulsory arbitration process, the parties may opt to submit their dispute to voluntary arbitration. Pag-usapan natin kanina yung voluntary arbitration, di ba? And letter I, yung Secretary of Labor and Employment, the Commission or the voluntary arbitrator shall decide or resolve the dispute as the case may be. The decision of the President, the Secretary of Labor and Employment, the Commission or the voluntary arbitrator shall be final and executory 10 calendar days after na matanggap ito ng mga partidos. Okay? Okay. Okay, nabanggit na rin natin yung mga prohibited activities. Ano pa ba yung mga mahalagang hindi natin na-cover dito? Yung kung may mga makakapanood nito na members ng Union, hopefully mas maiintindihan nyo to, o nakalagay naman sa Article 272 ang penalties sa mga magba-violate ng mga provision ng Labor Code. Okay? Meron pang mga special provisions dito sa Title 9, Article 273, yung Study of Labor Management Relations. Ayan, meron siyang merong kapangyarihan. Sinasabi nila yung kapangyarihan ng Secretary of Labor dito. Ayan, may visitorial power na naman. Ito, hindi pa natin nabasa ito. Merong similar dito yung tripartite kanina, yung pinag-uusapan natin na magdidikta ng minimum wage. Pero ito, Article 275, Tripartism and Tripartite Conferences, sabi rito, tripartism in labor relations is hereby declared a state policy. Towards this end, workers and employers shall, as far as practicable, be represented in decision and policy-making bodies of the government. Yan. Kaya kung mapapansin nyo, siguro may kinalaman dito yung mga groups sa Congress. Meron kaya ang tawag doon, party list. Yon. Sabi rin dito, Secretary of Labor and Employment at yung mga representatives niya can call a national, regional, or industrial tripartite conference of representatives of government, workers and employees for the consideration and adoption of voluntary codes of principles designed to promote industrial peace based on social justice or to align labor movement relations with established priorities in economic and social development. Sabi naman dito, yung government employees daw shall be covered by the civil service rules and regulations. Yan. So hindi kasali dito yung mga government employees, para lang sa kaalaman ng lahat. Yan. So parang na-cover naman na natin lahat. Miscellaneous provisions na lamang ito. Ayan, ito, mahalaga ito. Sana umabot pa yung battery ko. Termination of employment, Article 278, sabi niya. Article 279, security of tenure. In cases of regular employment, the employer shall not terminate the services of an employee except for a just cause. Mahalaga yun. Pag just cause or authorized by this title, pinapayagan ng labor code na tanggalin yung taong yun. So an employee who is unjustly dismissed from work shall be entitled to reinstatement without loss of seniority rights and other privileges, and to his full back wages inclusive of allowances, and to his other benefits or their monetary equivalent computed from the time his compensation was withheld from him up to the time of his actual reinstatement. So matatanggal lang ang isang regular na empleyado nang dahil sa just cause at dahil sa authorized causes. Okay? Sabi naman sa Article 280, regular and casual employment, the provisions of written agreement to the contrary, notwithstanding and regardless of the oral agreement of the parties, unemployment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except, ito na yon, where the employment has been fixed for a specific project or undertaking, the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is the season. Employment naman, Article 281, shall not exceed 6 months from the date unless it is covered by an apprenticeship agreement. So kadalasan din naman apprenticeship agreement, hindi dapat lalagpas. Dapat pag lumagpas na 6 months, considered regular employee na yun. Hindi nga lamang nasusunod masyado sa atin. Article 282, an employer may terminate unemployment for any of the following causes. Ito yung mga dahilan na pwede kang tanggalin sa trabaho. A. Serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. B. Gross and habitual neglect by the employee of his duties. C. Fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. D. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives, and iba pang mga similar sa mga nabanggit. Serious misconduct, yung sinasadya mong hindi sumunod sa isang pag-uutos na naayon naman sa batas. Hindi mo paggawa sa iyong mga duty. Pandaraya or willful breach doon sa pagtitiwalang binigay sa iyo. Paggawa ng isang krimen sa iyong employer o sa kanyang kapamilya. At iba pang similar doon. Yun ang mga dahilan na pwede kang tanggalin. Okay? Article 282 po yan. Tandaan natin yan. Article 284, pwede raw tanggalin ang isang tao, pwede raw gamitin ang disease as a ground for the termination kapag yung empleyado has been found to be suffering from any disease and whose continued employment is prohibited by law or is prejudicial to his health, as well as kung makakahawa siya sa kanyang co-employees. Pwede mo lamang gawin to provided that he is paid separation pay equivalent to at least 1 month salary or to 1/2 month salary for every year of service. Kung alin ang mas mataas doon, whichever is greater. Tapos, a fraction of at least 6 months being considered as 1 whole year. So, hindi ko na ipapaliwanag yun. Basta, yun na yun. Pakinggan na lang natin. So, termination ng employee, nakalagay sa 285. Sabi dito, an employee may terminate without just cause the employer-employee relationship by serving a written notice to the employer at least 1 month in advance. So, ito yung magre-resign ka. Or, letter B, an employee may put an end to the relationship without serving any notice kapag, pag pwede kang hindi na magpasa ng resignation paper mo kapag, and pwede mong hindi sundin yung 1 month rule kapag merong serious insult by the employer or his representative on the honor and person of the employee. Number 2, inhuman and unbearable treatment accorded the employee by the employer or his representative. Number 3, commission of a crime or offense by the employer or his representative against the person of the employee. Ibig sabihin nun, against sa iyong pagkatao or any of the members ng kapamilya mo. And 4, other causes na similar doon sa mga nasabi. Okay? Ang dami pa pala. Ito, akala ko matatapos na. 287, Article 287, retirement. Matatapos na to, retirement na eh. Sabi rito, any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. So pag retirement daw, ang isang empleyado ay entitled o may karapatan na matanggap ang kanyang mga benepisyo na naaayon sa collective bargaining agreement at ano pa bang pag-uusap. Okay? Kapag walang retirement plan daw or agreement, yung empleyado raw, kapag siya ay nag 60 years old na, but not beyond 65 years, which is hereby declared the compulsory retirement age, tapos nakapagsilbi na ng at least 5 years ang empleyado na ito, ay maaari na siya mag-retire at entitled na siya sa retirement pay na katumbas ng kalahati ng kanyang salary for every year of service. Ayun na naman, a fraction of at least 6 months being considered as one whole year. Okay? So yun ang sinasabi rito sa batas. Hindi ko alam kung may bago na batas na napalitan to. O ito pa, unless the parties provide for broader inclusions, pwede naman kasi may agreement ang mga partidos. Ang ibig daw sabihin ng 1/2 month salary, ang ibig sabihin nun ay 15 days plus 1/12 of the 13th month pay. Ulitin ko, 15 days plus 1/12 ng 13th month pay. And the cash equivalent of not more than 5 days of service incentive leaves. Yun ha. Okay. So natapos din tayo. Transitory provisions, natapos din tayo. Pinaghirapan ko po ito. Hindi ko nagawang maghirap ng ganito nung ako po ay nag-aaral ng batas, no? Next time po, dahil nabasa ko ng labor code, siguro maaari kong basahin next time yung kasambahay law o yung iba pang mga bagong batas na nagsusupersede o ibig sabihin ay naamyendahan o medyo hindi na useless na yung ibang batas dahil mayroon ng special law o mayroon ng bagong batas na ginawa. Susubukan kong basahin siya at susubukan ko rin magbasa ng mga jurisprudence para alam nyo yung kaso, or at least hindi ko man babasahin yung buong kaso, babasahin ko yung desisyon para alam nyo yung kung paano i-interpret ng Supreme Court, para alam natin pare-pareho kung paano i-interpret ng Supreme Court yung mga batas natin. Kasi po, para sa ating mga layman, gusto ko lang i-share, ang Supreme Court po ang last resort, the court of last resort. Kung anong sasabihin niya ay magiging penal na. Okay? Kung ano ang interpretasyon ng korte ng Supreme Court sa mga batas, yun ang siyang susundin natin. Okay, yun lang po ang gusto kong i-share sa mga katulad ko layman. Sana po marami kayong natutunan, lalo na sa mga manggagawa. God bless sa lahat ng manggagawa, sa mga taong katulad ko. Ingat po kayo and peace. Muli, ito si Lolo Ray para sa isa na namang edisyon ng In Layman's Terms.